she sort of becomes discombobulated.
You're going to convince me to hold your client in contempt. She isn't even present. All she needs to do is tell somebody else, not him, make sure you give Dad the homework folder.
Alex here with part 125 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off in part 24 with a little tidbit from the writ petition case. We're going to see a little bit more of that coming up in the series, probably 2 videos from now. But we are all here to watch a hearing video. As you know, the introduction of this particular video has probably piqued everyone's curiosity. That is what we will be going into. My mindset going into this hearing was mostly positive, and that is, again, because of the Supreme Court's intervention on that other issue. I had a strong feeling that the Supreme Court's intervention into the case would also have an impact on this judge, because he would see not only was a writ of mandamus issued, and I don't think at this point he's been transferred into that other case, but it's coming very soon. But he would be aware that a publication issue, which is the bigger, deal, because now it's not just a guy in his courtroom. Now it's a person who has expanded Nevada case law for the entire state. Still, in hindsight, looking back, I think my optimism was somewhat misplaced. My memory of the hearing was mostly, I don't want to say mostly negative. It was a mixed bag. I felt good that the contempt was going to issue, and it did issue. I felt good at the way that the judge handled my ex when he held her in contempt, and we're going to actually see that in video, and I'm going to talk about it a little bit more. But I don't feel too good about how the judge handled the child support stuff. And you guys, everything is a sliding scale when it comes to the perspective that I have in this video, because on the one hand, you don't necessarily need to expect to get everything you want when going into court, but on the other hand, that just takes you into the thinking that I talk about in the video, meta rulings, which is to look less at the merits of the issues before the court and to look more at what people are getting, which is the wrong way to look at something when you're going into a court of law. And if you want to know more about what I'm talking about, please watch the video meta rulings, because that's where I go over the issue of judges making decisions not based on the law, but rather based on how they think people are going to feel based on what they get. And so this is what often leads to the problems that I described in the other video, which is best interest of the parents, where the court becomes so concerned about what the parents expect to get out of the hearing that they aren't even paying attention to the best interest of the child. So all of these things tie together. Anyway, I do think that this is one of those videos where we're just going to need to get started and get right into that hearing.
It doesn't please me to see you back again so frequently. I can't believe that it's good for your children.
So here's what I was talking about in the video. End of filings does not equal end of abuse. The judge doesn't say that he can't believe our child is suffering. He says he can't believe that we're back in court. That's the distinction. He connects being back in court with the child suffering. He's got it backwards. He doesn't realize that there are situations where children are suffering, but the parents don't come back to court. And this is where the priority of a lot of the family division judges is. It's not so much in the best interest of the child. It's in stop putting work in front of me because it's annoying.
But that having been said, we're on the record in the case of Alexander Falcone versus Monica Farrar, FV08-03200. Mr. Falcone is present without counsel. Ms. Farrar is present with Ms. Berning. We're here on an order to show cause that's been fairly limited in scope. Since I issued this order to show cause, 2 additional motions have been filed. It is not my present intention to schedule subsequent hearings for those motions. So if there's any additional evidence to be presented on those motions, please present it today.
So I don't think that this is something that the judge should do, because there may be situations where the court has not been fully briefed. I suppose if the court has been fully briefed, then that's okay. You can go ahead and do that. But still, you might have an objection from a party or an attorney that they didn't come to court anticipating that this was going to even make it to an evidentiary hearing. And so this could be another relevant objection to the court's handling of this. I understand that he's trying to save judicial resources and stuff, but he should have filed something indicating to the parties, something placing us on notice that he intended to resolve both of these motions today in the context of an evidentiary hearing. And again, that matters, because if something is going to be addressed in an evidentiary hearing, you have to bring your witnesses and your proof. And it's not something that the parties and the attorneys are just supposed to intuit. We're not psychic. We have to know what it is that the court intends to do. So luckily, this isn't a situation where I think it would have backfired on me. Actually, I may reserve comments on this until later on in the hearing, or maybe even at another point in the My Docket series, because what the judge is doing here may actually have been something that prejudiced me, but I'm not sure yet, because I don't know how he's going to handle the child support issues that are pending before the court. So let's go ahead and hold off on that until later, and I'll go ahead and reference this particular point in the video if I need to. But yeah, this is not something that necessarily you should just be willing to jump into if you're representing yourself and a judge says, hey, you know, all that other stuff that's pending, we're going to deal with it today as well. It's okay, I think, to do that in the context of what do they call it, a hearing on law and motion, or an appearance hearing, because those are just hearings where you're trying to tell the court this is the issue and I need this to go to an evidentiary hearing. But it's completely different for him to do what he's doing now, which is to say, hey, let's just hold an evidentiary hearing on that other stuff too. That's different. Those hearings are a much bigger deal, and sometimes they even require discovery and stuff. So I mean, I suppose he's giving us an opportunity right now to object, but it didn't really feel like it the way that he stated it.
Sir, it's you obtain the order to show cause, you can proceed.
As the court mentioned in its order, there was a conflict with the school, with the education. The court ordered that the child attend Coral Academy of Science. Throughout the first year, Farrar was not exchanging the homework packets with me. So during a subsequent motion, a motion for a change of custody for absences and all that, I addressed that issue. Came to court. On February 8th, the court ordered homework packets to travel with the child.
I just want to quickly mention, if you're going to refer to your ex by the last name, make sure you put a Mr. or a Ms. in front of it. It's just an issue with regards to, I guess, politeness or formality that I wasn't aware of at the time. It doesn't blow up on me in this hearing, but it does blow up on me way into the future with another judge who, I guess she takes offense to it and she thinks I'm doing it on purpose. But I mean, I just wasn't aware that that was a problem. That's how I wrote her name in the briefs, and so that's how I started to refer to her in the actual hearing itself.
After this order, there were still occasions where Farrar was forgetting to exchange the packet. There were also occasions where Farrar was leaving the packet with the teacher, even though that argument had been brought up on that hearing and rejected by the court. And there were occasions where she actually did transmit the packet. More often than not, it was not transmitted.
I feel like I'm doing a little bit better here than I was in previous hearings, but I think it would have been a lot cleaner of an argument if I broke it down into 3 different things, 3 different assertions. So, number 1, the court has ordered the homework packets to be exchanged. Number 2, violations of the court's order occurred on dates, and then give the dates that they occurred. And then number 3, I'd like an opportunity to question my ex or narrate to the court, provide testimony to the court in support of each of these allegations, and that's it. And then see what the judge said. But I feel like I'm just I'm not sure what to do. And so I'm covering a little bit too much or a little bit, I guess I'm going into more detail than I need to. Most of the case is going to be testimony by my ex, not so much a presentation, at least not at this point in the process. Maybe in closing arguments, I could address some of the arguments that she's making, but I think that this would have been a more clean approach, is to just, as I mentioned earlier, number one, this is the order of the court. Number two, these are the dates that the violations occurred. Number three, let's just get into testimony. Just boom, 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 go. That's what I would have done if I could, use the experience that I have now back then.
I have a few specific allegations. The March 28th violation, when she did not bring the homework packet, I had been at this point, anytime she forgot to bring a packet, I would offer suggestions, drop it off at my work, leave it with the school. I mean, this was not in compliance with the court's order, but it would have sufficed. I would have been able to get it some way or another. My objective was not to just find some way to contempt her out of the blue. I was trying to work around the violations as best I could. The first one where Farrar said that she would provide me with a packet, that was the March 28th violation. I believe it was Wednesday, of course. She had until Friday to scan it to my work. She did not do so, even though she said she would. That's evidenced in her opposition exhibit 4. On April 22nd, that's when I filed a motion for order to show cause. That was basically triggered by the final refusal to transmit the packet or exchange it. On May 1st, after I filed the motion, she committed a second violation. Did not bring the packet.
Wait. You this is the third date you're giving me, and you just told me it was the second violation. I'm just
Second
trying to stay
violation,
with you.
third date. The second date, the April 22nd, was when I filed the motion. I've got a little time.
Oh, that wasn't a violation.
No.
The second violation was May 1st. Okay.
May 1st, right. This time, she did not offer any alternatives. The second violation is evidenced by the affidavit of Brittany Ames on file, the witnesses present.
Just a clarification, I said evidenced by the affidavit on file. An affidavit is not evidence. That is just what's going to get you to court so that you can present the evidence at the evidentiary hearing. The evidence itself would actually be Brittany testifying on the stand. And I also don't want to take away from the fact that my testimony does count as evidence too. So I'm right now in the dual role of an attorney and a party, but when I make assertions of fact that I was present at, those count as testimony because I'm representing myself, and that is also evidence. And I just wanted to clear that up for you guys just so that there wasn't any confusion.
May 6th, that's when she filed the opposition to motion. She admits that a couple of times she accidentally forgot. May 8th, only 2 days later after she filed out her opposition, she apparently took the child to another state. He missed 4 days of school. If I would have at least been let know this, I could have arranged to get the packet, but that day she didn't transmit the packet either. I believe that was a Thursday or Friday exchange.
Okay, so the court gets a little confused with my timeline because my timeline includes things that are not violations of the court order, and these are filings. And I do want to mention to my viewers that it is nice to have a script to go through, but I think it also will sometimes hurt you more than it helps because you really need to be able to go with the flow at these hearings and not be stuck going through a script like that, because then when things go sideways or you get interrupted by the court, all of a sudden you lose your train of thought and you can't focus. So I think that my approach would have been better if I didn't necessarily go into the dates of the filings, but rather just go into the dates of the violations and use the filings if I need to in that particular argument to make my case sound better. So for example, I could say third violation, my ex didn't exchange the homework packet. And just so you know, at this point, we had even filed a motion and an opposition. So she was well aware, we were going to court on it. That would be good enough. I don't really need to go into the dates and times of the actual filings in the timeline. That's already been put into the briefs anyway. So this is just an unnecessary extra. And this might seem like nitpicking to you guys, especially for a non-attorney, because how are we supposed to do a great job when this is not our career? But these little things make huge differences. The smoother, the cleaner, the more concise, the more efficient your argument is, the better your presentation, and it does make a difference. And so just as important as it is to throw things in, is the importance of taking extraneous or extra details out. It's a different situation when you're putting together your written briefs than when you're actually at an argument, at a hearing, and putting on a presentation for the court. There's just a different approach. There's things that you need to highlight there that you don't need to discuss as much because they're already covered in the writings anyway, stuff like that. So I think that that me going through this scripted timeline is doing more harm than good. It would be better if I didn't have to do that. And if the court has questions on these details, of course you'll be able to look them up. It's not like if you don't say it, you're going to waive your right in some way. But yeah, guys, just focus on the big picture stuff at these hearings. Let the court or your opponent give you the questions. Let them nitpick, and then you can deal with the stuff at that time. You don't necessarily have to read into the record everything that you put into the briefs.
May 14th, I filed reply to opposition.
Wait. Okay, so the first violation was March 28th. The second was May 1st. When was the third violation?
Third violation was May 8th.
Okay, now what you told me there is she missed 4 days of school.
Monday, I believe it was like a Thursday, a Friday, and
Was there also a violation in relation to the homework packet?
Yes.
Was there a homework packet if the kid wasn't in school and it was out of state?
It transmits on. The teacher gives it to, or would have given it to her on Monday. I don't know.
Was she out of state?
Yes, she was out of state.
Then she couldn't get it.
Okay.
Is that true or not true? I'm trying to understand
true.
what you're saying.
That's true. She wasn't there, so she couldn't have got it. That might be an excusable violation.
Okay, so I just assumed that the court or the judge was trying to defend my ex there. You should just stick to answering the court's question, not trying to figure out what it is the court is trying to insinuate by a question. And then, of course, you don't have to bring up your opponent's defenses for them. Just let your opponent bring up their own stuff. Sometimes when you're representing yourself, you get into this weird role where you don't want to sound like a bad person, so you want to acknowledge the good things that your ex is doing. It just confuses the court and it frustrates the process because that's not how the process was designed. You can bring up your assertions, let your opponent bring up their defenses on their own, and then if you need to reply in some way, shape, or form, you can do that. You'll be able to say something like, okay, that was a fair argument on reply, but you don't have to try and lead your opponent. All it does is add confusion to the already confusing process for a non-attorney.
Okay, what's next?
Next is I filed on March 14th the reply to opposition.
Sir, I don't want to hear when you filed things. Okay, you're trying to tell me the violations. I'm trying to stay with you. It's not the most clear explanation, so I'm asking you to keep it clear. Go to the next violation, please.
The next one's in my reply. The exact date is...
And you don't need to list them all if you want to. I thought that's what you wanted to do. I'm not trying to tell you how to present your case.
There was one more violation after that where she did not bring the homework packet.
So there were a total of 4 violations?
Total of 4.
Well, you said earlier that more often than not she didn't comply.
I don't have evidence for the others, so I didn't want to say, I've got her for 22 violations.
Well, how many weeks have there been? Roughly?
Roughly, let's see, this was...
30?
Okay, so I made another mistake there. I said there wasn't any evidence for the others, but again, this is my misunderstanding of what evidence is as a non-attorney. You can use your own testimony as evidence, even if you don't have something, amazing to help, like an email or a text message or a witness who was there. And that is something that I think I should have raised at that hearing. I should have listed all of the infractions, even the ones that were just me having my own word sort of to support them. And then, of course, when you go into the actual testimony, yes, you can highlight the incidents that you have better evidence, like a response, in an email or a text message from your ex, like I had in this particular case, or my wife, Brittany, could come and testify. I mean, those are the ones that I could focus on, but I shouldn't just assume that just because all I have is my own word, that doesn't count as evidence and that can't be asserted, because it can be asserted, and honestly, it should be asserted. The court can later on decide at the hearing, hey, you didn't have enough, it was just your testimony on those, but you did have enough on these other 4, so, you're going to still win your hearing. Or the court could say, hey, you know what, I think you sound pretty convincing, I'm going to just go ahead and say all 18 of those are violations. Or you never know, your ex could get up on the stand and you cross-examine them and they just totally choke, and the next thing you know, you actually end up getting, all those other violations land just because your opponent said things that were ludicrous on the stand. So you just don't assume that your own word is meaningless. In the law, you as a party count as a witness and your testimony counts as evidence. So yeah, I mean, some judges will take it with a grain of salt, but it's still a grain of salt. So just want to let you guys know all about that. In fact, I have a video on this. I think it's discussed in the video testimony as evidence, and if it's not in that video, then it's in the video standard of review. It's in one of those two.
Between about 8
There have been a total of 8 weeks.
from the first violation. The ones before that I wasn't keeping track of. I wasn't thinking in my head I'm going to need to file a motion for this. I was hoping we could work it out.
All right. Sir, I'm testing your statement that more often than not she's
Right.
violated.
Right, and that...
Okay,
that- yeah.
you've just given me 4 violations. So if I count the whole number of weeks that she's supposed to be in compliance with this order, then there are less than 8. Is that correct?
Yes, I would estimate there were 6 violations. I don't have proof for 2 of them.
And how many weeks have we talking about
Talking
here?
between 8 and 10.
Okay.
And then
What else do you want to tell me?
I understand that her defense is that they were not deliberate, willful violations, and in this sense, I would ask the court to get to the bottom of 2 issues. Was the conduct totally under her control? Because there's a difference between getting an accident, such as when you get a flat tire, something you can't control, or forgetting to set your alarm clock. Both of them could be perceived as accidents.
Sir, I don't want you to deal with her defenses right
Oh, okay.
now.
So is this
Tell
just
me what
evidence and testimony?
she's done wrong.
Okay.
Okay, is there anything else to say on that?
Not on that particular issue. I'm just going through my notes.
And it's nice to see that he caught that. You know, one of the things that I could have mentioned was, I'll deal with any of her justifying excuses on reply, and that's it. I could have just said that one thing, give me an opportunity to reply, please, and then wait and see what the defenses are, because you're just wasting time otherwise. You could be bringing up defenses that you think they might raise, that in actuality they don't really feel like they're going to raise at all. And so it's just more efficient to wait and see what the defenses are going to actually be, so then you can save the court's time and address only those specific defenses.
And she gets a chance to make her defense before you get to respond to it.
Right. I'll let her make her response, and then I'll reply to that, depending on what she says.
Thank you, sir. Hello. It's your
Good
turn.
afternoon, Your Honor. Your Honor, I think the best way to respond to this is if I may ask Ms. Farrar a few questions. May I
All
do
right.
that?
However you'd like to present your case.
Thank you. Ms. Farrar, you've heard the allegations by Mr. Falcone, is that correct? You have to answer audibly.
Yeah.
And he listed in his responses some 4 different occasions, or 3 different occasions that he had proof for, as I heard him. One was March 28th, where he stated that he had offered for you to drop the paperwork off at his work. Do you recall that?
I don't know the exact dates. I could look it up in my email or my phone if it mattered, but the first time I forgot the homework after court, I was freaking out because I was like, oh my god, I forgot the homework. So I didn't realize it until after I got to work. So I sent him an email saying that, you know, I had left it in my car. I was really stressed out, stressful dropping him off, and it was on the seat next to me, and I didn't give it to him.
Did you do
And,
did you make any offer
I
to
sent
him?
him an email immediately and said, hey, as soon as I get home, I can scan it in and send it to you. And he sent me a bunch of negative emails back. I shouldn't have asked him. I shouldn't have asked him anything. I should just scan it in and send it to him. But he sent me an email back, giving me a hard time. Then he suggested I drop it off to his work. I'm not comfortable going to his work. And suggested I drop it to his house. He had his address. I don't want to go to his house. And then it was a bunch of emails after that, and I was like, okay, you know what, it's 1 page of homework, I'm sorry I forgot. And he's going to send me a whole bunch of nasty emails, and I just couldn't handle it. I was like,
When you say
okay.
there are nasty emails, what can you characterize for the court what Mr. Falcone said to you in the emails?
Don't let your opponent do this. Don't let them characterize emails. Have them read into the record. Have them reviewed by the judge. Actually look at the email, Your Honor. Don't just go by what she's saying.
It was a mistake. It wasn't on purpose. It was because I was stressed out. It's stressful seeing him, and everything I do is, he's going to take me to court, he's going to do this, he's going to do that. I was stressed out before he responded to me because I knew.
Ma'am, did you send it to him? Did you copy it?
No,
Send
he
it to
told
him
me
electronically?
He told me he couldn't print it. He told me he couldn't print it out.
Well, why didn't you just send it to him anyway?
Because if he wasn't going to be able to print it out, Army wasn't going to do it anyway, and I could have him do it when he came back to me on Sunday.
Okay,
He gives it back to me to turn in anyway.
all right.
Then there were two other times that Mr. Falcone mentioned. One was...
Three other times.
Oh, three other times. There's the May 1st, when you didn't get the, when he alleges that you didn't get the homework. Do you remember that time?
You know, most of the time I try and have somebody else at the drop-off with me because it's so stressful seeing him, interacting with him, that I give him to a friend of mine, and then I leave before he can get there, and the friend gives him to him. And there have been times that he told me that the homework didn't come to him. I didn't know, and it was in my friend's car, and my friend never told me, oh yeah, your kid dropped it in the back seat. Didn't even know it was in his back seat, and that's my fault because he's dropping him off to my ex for me.
So she's admitting that this is her fault because she knows it's a defense for contempt. It's not a willful violation if you tried to do something and your buddy didn't do it. And this is one of the reasons why I don't like people using third-party designees in high-conflict child custody cases, because they are clever enough to find out how contempt of court works, and they will blame their own designee for violations of the court order. This is totally a common tactic by a high-conflict child custody ex. Without question, it is.
But I didn't know that he didn't get the homework until he was upset at me later for it.
When did Mr. Falcone tell you that he hadn't gotten the homework packet?
I don't know.
Was it the same day that Army was dropped off at school?
I don't know. Could have been, it might not have been.
Now, Mr. Do you have, other than there was another time when you were out of state, is that correct?
Yeah.
Was that and what were you out of state for?
A family wedding, and I had sent him a letter in the mail like I'm supposed to with the dates, and I had let the school know ahead of time, and I don't see how I'd be responsible for turning homework over to him when I'm not dropping Army off to him. And he didn't miss any homework because I scheduled it ahead of time with the school, and there was no homework to hand over. There was no homework to do. It was all taken care of in advance.
Other than were there any other times that you can recall that you forgot to make sure that Army went to school with the homework packet?
Oh, no. He never forgets to go to school with the homework packet. I worked very closely with his teacher, both for that and summer school.
And had the teacher made a different suggestion to you with regard to the homework packet between you and Mr. Falcone?
Oh, his kindergarten teacher?
Mm-hmm.
Yes, she was going to just give the homework to each of us on our days, right? Like give me homework on Monday and Tuesday, whatever, and then on Thursday and Friday, if there's homework, he gets it, right? But he doesn't want to do that. So, and summer school, I didn't have a choice. Summer school, she just gives you a folder, and then you bring it back. It's not like there was homework to give to him. So
you mean you bring it back the next day?
Mm-hmm. Yeah, there was never homework for him to do.
Then in January, how many school weeks were there for Army in January?
I don't know.
Do you recall after Christmas vacation when students went back to school?
No.
Would
It's
it
my
refresh
first time I've done this, so.
Would it refresh your recollection if you looked at a calendar?
I don't know when the school year started. I would have to look up their school calendar. Does it matter? Yeah.
How many weeks in February did Army go to school?
All of them?
So 4 weeks?
Yeah.
And what about March?
Same thing, all of them.
Also 4.5, 5 weeks. In April, how many weeks did he go?
Same thing, all of them.
And what
And
about
if he had a sick day here and there,
May? How many weeks of school was there in May?
you know, I think, I'm trying to remember, school got out in the end of May, I think. So not all of May.
So it would be a fair statement to say that there were probably 4 weeks in February, 4 or 5 weeks in March, 4 weeks in April, and 4 weeks in May that Army was attending school. Is that correct?
Yeah, when we went to the family wedding, we left Thursday after school, and came back Tuesday afternoon. So.
And when was it ever your intent? What was your intent when you forgot Army's homework? You knew there was a court
I
order,
didn't have
correct?
an intent. It was an accident. I was stressed and not thinking about the homework packet on the seat next to me. There was no intent. I intended to give it to him. I brought it with me and I didn't hand it to him.
Hey guys, normally I wouldn't want to interrupt at this point to bring this up, but I know that I never actually did this, so if I keep waiting, I'm not going to have an opportunity to bring this up. What I want to say to you guys is I think that I should have insisted on questioning my ex with regards to the specific incident where she failed to provide the homework packet, which is what she's talking about right now. She's saying she left it on the car seat. And I would have liked to have questioned her on the stand, or even if she wants to stay next to her attorney, that's fine. I would have wanted to question her about that specific incident, because that is a specific incident where there's an email exchange that gives her the opportunity to rectify the situation. And I think that would have been the best presentation that I could have given the judge, because she's kind of trying to avoid that. She's kind of trying to dance around it a little bit, and he figures that out on his own. But I do want to let my viewers know that that is an opportunity that I think that I should have taken. I should have questioned my ex myself, and I should have gone through that specific incident from the violation to each email, go through one email after the other, read each of those emails into the record, because that's the best evidence. And then once I finish that, then my ex's attorney can cross-examine her, and then we can deal with that, accordingly. But this is, I think, one of the biggest misses for me. And again, I end up winning the hearing anyway, and she's held in contempt of court. But that is a little bit of luck on my part, I think, because I am totally dropping the ball here and I'm missing my opportunity, or I already missed it because I kind of just handed the case over to her. But I presented my I presented my case with my own testimony, and then we went straight to my ex, when I should have presented my case with my testimony plus some of my ex's testimony with me examining her, and then possibly even Brittany's testimony with regards to that one specific incident. And again, guys, this is just because I didn't know any of this. I was a complete newbie and had no clue how any of this worked. So I'm trying to give you guys some of the benefits of my hindsight on definitely missed opportunities, on a better way that I could have put on my presentation than just reading through the scripted list of facts. Anyway, you guys get the gist of what I'm talking about.
And on these occasions when you forgot, did you try to make contact with Mr. Falcone?
Yeah, I emailed him, but like I said, every time I try and do anything with him, he's really negative and rude. And argumentative. Nothing that I suggest works.
Your Honor, does the court want to hear any other testimony on any other matter pending before the court?
I've indicated that 2 additional motions have been filed and that I don't intend to schedule hearings for them. If there's anything that you'd like to say in relation to either of them, I'd like to hear it.
Yes, Your Honor. May I do so then?
Yes.
Your Honor, with the matter of the scheduling of the dental or of medical appointments, I would ask the court to consider using the wizard, where the parties could both put online the appointment.
I want to know why your client didn't comply with the existing order. It's a motion for an order to show cause. So while another remedy might be appropriate to consider, I want to know if your client complied with the existing order, and if not, why not?
Can
May I have my client explain?
You can do whatever you'd like.
Okay, so first he filed a motion saying I wasn't acting quick enough on his dental. Okay? When I was waiting because he told me that he was going to get supplemental insurance so that we could afford it. But then he didn't. Then he filed a motion saying I wasn't acting quick enough. Then he sent me an email telling me to make the first appointment possible.
Then you don't have to obey his emails, but you do have to obey court orders. They're not optional.
Well, he told me to make an appointment as soon as possible, and that the 14-day thing didn't matter to him. And I did, and we both went.
Do you have these emails?
Yes, and we both went.
Maybe you should show them to me.
Well, we did, didn't we?
They're in the exhibits, Your Honor.
So we both, well, that was the first one. So we both went. He didn't have 14 days notice then, and we both went, and we scheduled everything we could schedule, and then they worked with my insurance company, and they said my insurance company was going to cover everything because it's complicated. They want to do something where the dental doesn't cover all of it, and supposedly my medical insurance was going to. They told me they would cover all of it. They said they talked to him, it would cover all of it. I called them, they said they would cover it. So we scheduled a surgical date finally, and I told them about it. It was on a Wednesday. They called me up on Monday and said, oh, we forgot. You have to meet with the surgeon before you go in. The dental surgeon, and you have to meet with her because the doctor or the dentist that you
Ma'am,
had
I'm
met
interested in your compliance with the court order, so I don't know what all this detail has to do with that.
because they called me Monday morning and said, you have to come in and meet with her or the surgery can't happen on Wednesday. So I did.
And was the Wednesday surgery something that Dad already knew about the schedule?
Yes.
Okay, so this was
So
a
they would've canceled
pre-operative checkup, and you were given little notice.
And we didn't make any decisions or anything.
I understand what your explanation is. Is there anything else you want to say?
And then it got canceled anyway because then the next day they called me and said, oh, your insurance doesn't cover it. And I couldn't come up with that amount of money in 1.5 days.
Okay.
So we didn't get it done anyway. And he scheduled an appointment with a different dentist because I wanted to change anyway. And the dentist he scheduled with, he didn't give me 14 days notice, and I was fine with that. And it's a great office and great dentist, and so we're working with them now.
I just want to clarify that when you violate a court's order, you can do that if there's a justifying reason. And so when she's saying, hey, I didn't give enough notice, he didn't give enough notice, and everything was okay because it was urgent, the key here isn't so much you can do whatever you want just because something is urgent. The key is that what you do to justify a violation of the court's order will control whether or not you can be held in contempt of court. So by her argument, and later on the court's going to get cute about this and the judge is going to say, hey, well, it was urgent, right? By her argument, and then the judges, when you actually get to hear what he has to say about it, you can just do whatever you want once you decide that you can violate a court's order, which isn't true. According to the Supreme Court of Nevada, what you do when you violate the court's order is taken into consideration to determine whether or not the violation is justified. So that conduct actually is relevant, actually does matter. If you have an urgent situation and you have a 14-day notice provision in your court order, you're not going to be held in contempt of court if you violate the court's order to get your child some emergency care. And in the process of violating the court's order, you give your opponent as much notice as you possibly can under the circumstances. But by the argument that my ex is bringing up, and later on by the argument that the court kind of throws out there, you can not just say, hey, well, since this is urgent, I'm going to just schedule this now, and I'm not even going to tell you. Or I'm going to tell you 5 minutes in advance. Or I'm going to tell you by a medium that will virtually guarantee that you won't even know what's going on. They expect you, and by they I mean the Supreme Court of Nevada, they expect you to do the best you can and act in as much good faith as possible when violating a court's order. They don't expect you to say, hey, look, I'm going to violate this court's order and act in I'm going to show as much bad faith as I possibly can in the process of doing this. And then later on, if somebody tries to, call me out on it, I'm going to say, well, I didn't have to comply because it was an emergency. The conduct matters. When you violate the court's order, you should do everything you should do everything that you possibly can to show the court that not only was the violation the last possible resort available, but also that you did everything that you possibly could to show the other side, to include the other side in the process, to notify the other side as to what's going on. And that's just not what happened in this situation. And my ex doesn't want to talk about that because that was her goal. And the judge doesn't want to talk about it later on because I feel like he's just trying to poke me in the eye over a particular thing that I brought to the court's attention. And it's not cute when he does do that. It's going to come up probably within the next 5 to 10 minutes. And it's just one of the memories that I have is a judge who is trying to find any reason that he can to deny the relief that I'm requesting. And it really shows in this particular situation because he doesn't want to look at my ex's conduct with regards to the violation in any way, shape, or form. He just wants to go and find something wrong with what I'm bringing to the court's attention because he just wants to teach me a lesson. And that lesson is, don't come back to court. I'm tired of seeing you. You'll see what I'm talking about momentarily.
So nothing, happened from that appointment, and I didn't try to do it that way.
Okay.
If I had not done it, they would have canceled the surgery, and that would have been my fault too.
I understand. And counsel, you want to suggest that I order the use of the family wizard?
I'll tell you why, Your Honor. The reason is that it would allow the court to look in on the matters of the case. It also would give both parties a way when something is scheduled to do so quickly, where both parties could look online to see that happens. It's my understanding that email can, goes into my client has told me that she has emailed Mr. Falcone when he has been at a place in transit to a doctor's, not a doctor's appointment, emergency room, and that he has gotten email from her. So the system that the court has put in place is currently working. So we'd be asking to keep that with the addition of using the family wizard so that the court could see that the appointments were being scheduled and that both parties were able to see that. And then the court can also see when the appointment is and when it was scheduled to confirm that in fact both parties are complying with the order.
All right. Is there anything else you want to say?
Yes, Your Honor. This steps outside a little bit, but it looks at the global picture. Mr. Falcone and Ms. Farrar have been before this court numerous times, and the court has looked at this matter many, many times on issues that are fairly de minimis. When a motion is filed by Mr. Falcone because of one missed appointment due to a 30-minute notice, it seems like a very small thing for the court to
Your argument begs the question, though. If you're concerned that he's filing on de minimis things, why do you keep giving him opportunities to file by not complying with the order?
If this judge would have used that wisdom for the entire case, he would have actually, I think, protected our child a whole lot sooner. You are creating situations where I have no choice but to go to court to deal with the issue. So exactly what the judge said here. If you are tired of going back to court, why do you keep doing things that cause me to file motions? They don't see it that way. They see it this way. If you don't want to go to court, why are you filing motions? And they just figure they can do whatever they want, and I should just not want to go to court and therefore just let it happen. And this is something that I think a lot of parents actually do because number one, it's expensive. Number two, it stresses them out. And number three, you have judges like this who make these snide comments about how they're sick and tired of seeing you. And so that sends a message to the protective parent that this guy doesn't want to see us anymore. And that also sends a message to the high conflict parent that this guy doesn't want to see us anymore. So I'm going to do a whole bunch of the stuff that I've been doing, knowing that this judge isn't going to want to see us anymore anyway. So he's not going to step in. Remember, the high conflict parent is the ruthless parent. That is the parent that does not lose any sleep at night over abusing and neglecting the child. The protective parent is the one that gets anxiety from that. So it's in the benefit of the high conflict parent, the personality disordered parent, the emotionally immature parent to continue to do what they're doing when they see a judge who says things like, I'm tired of seeing you come to court. If this judge would have said what he just said from the beginning until now, I strongly suspect that my ex would not have continued to do the things that she did that led to the termination of her parental rights. That was the most correct, most accurate statement that I think that this judge could have made throughout the earlier portions of this proceeding. If you don't want Mr. Falcone to file motions, stop abusing and neglecting your child. That's what you're supposed to stop doing. And he didn't give that message from the beginning. In fact, he gave quite the opposite. And so she, like any emotionally immature parent, they're not looking for the best interest of their child. They're looking for, what can I get away with? How can I get revenge? How can I continue to keep the conflict going so that I can feel relevant? And these are the things that they're looking for. And so they pay attention to these cues from the court to determine what it is that they can get away with. And then they will go ahead and do those terrible things to the child because that's what they want to do. A lot of times I think a lot of these high conflict parents will sometimes fall back on the defense of, okay, well, I didn't know what I was doing, but it's not really true. They do. They know very much what it is that they're doing, and they do it on purpose. The question is, how can they get away with it? That's always the question in their mind. If I go and do this particular thing, what can I do to make sure that I get away with it? And this is all, pretty much everything that I just said is the foundation of what I discuss in the video, Many Fine Lines. So if you want to know a little bit more about what I'm talking about, please take a look at the video, Many Fine Lines, because what I just described over the past, 2 or 3 minutes that I explained all of this is the foundation for what is that video.
Whatever I do, he's going to file.
Your Honor.
Ma'am, if you are sending somebody to drop off your kid's homework and it's in the kid's back seat because that person doesn't appreciate that they've got an order, that you've got an order to give them the homework, what's your excuse for that? I mean, if you don't want them to file for little things, stop giving them little things.
Your Honor, what I was going to suggest is that in other cases, I know there has been a parent coordinator. And while Mr. Falcone has repeatedly said that mediation wouldn't work, perhaps a parent coordinator might.
Never, ever, 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 ever consent to a parenting coordinator in a high conflict child custody case, ever. Please watch my video on parenting coordinators. The Supreme Court of Nevada has stated that a parent has the power to veto the appointment of a parenting coordinator. But once you agree, it is very difficult to get rid of them. You read that right. You heard that right. If you say, Your Honor, I object to a parenting coordinator, the court is banned from using a parenting coordinator. The Supreme Court of Nevada stated that the use of parenting coordinators without the consent of a parent is a violation of your constitutional right to petition the courts for redress. This is a very serious issue for the Supreme Court of Nevada. If you object to the appointment of a parenting coordinator and the court orders one over your objection, it will be overturned on appeal. It is something that they take very seriously. If you want to learn more about what I'm talking about, please watch my video, Parenting Coordinators. I explain why it is a terrible idea to use them in a high conflict child custody case in that video.
The value of that would be that the court would have an independent person, not counsel for either side, that would have input with the court.
I'm not opposed to that, but it sure would be simpler if your client would comply with the existing court orders.
I understand, Your Honor. I would tell the court on this matter that as far as I don't know how to tell the court, because the court has read the motions. I know there is quite a bit of stress for Ms. Farrar when with any interaction with Mr. Falcone. There are situations where they go to a dentist appointment and Mr. Falcone sidles up to her, gets close to her, makes her feel uncomfortable.
So not only is that a lie, but it's the exact opposite. I would sit as far away as I possibly could from her, and then she would come and sit uncomfortably close to me. I'm not sure if this attorney is brazenly, asserting this lie, or if she's just taking advantage of the fact that her arguments are not under penalty of perjury. This is because arguments of counsel are not evidence, nor do they establish facts. The Supreme Court has stated this repeatedly. I suppose it's possible under the rules of professional conduct she can be held liable for deliberately telling a lie in court, but she'd probably just say she was confused or didn't know what the truth was. In any event, I forgot to mention this earlier in the video, but I'm not going to deal with my ex's factual allegations in these hearing videos. I never do, because then the video is just kind of a silly, oh, that's not true, true. All I'm going to do is continue to bring up legal things that jump out at me. So I'll go ahead and take this opportunity to tell you that this isn't true. If there are any other factual allegations that aren't true, I'm not going to really talk about it because there's no point. And the case is closed anyway. I already won, so I don't need to really explain myself to you guys. But I did want to mention one more thing about the assertion by my ex's attorney on my ex being really stressed out with interactions with me. This is something that I have stated repeatedly with high conflict exes. They are not stressed out. They love the conflict. They might act like they're stressed out. They might tell the court or their lawyer that they're stressed out. But in reality, they love the conflict. They love the interactions. They love them. They crave them. And if you've been watching this series from the beginning all the way up to this point in time, you will know that there were numerous opportunities where my ex could decrease the number of interactions. The first opportunity, and this is probably not even just one time, probably 2 or 3 times that I brought this up, was me trying to reduce the exchanges over the week so that we could go to a week on, week off schedule, or that we could go to at least a half week schedule. That way there would be less interactions. And if my ex is super anxious and stressed out when she sees me at these exchanges, she should be all over that. She should be like, yeah, I would love to see him only once a week, or even better, since the child is in school. Now we can exchange at the school. I don't even have to see him. She didn't do that. She opposed that at every possible opportunity. And she would say things like, oh, I want to make sure I can see the child as much as possible, which is silly because whether it's week on or week off or multiple different exchanges, you're still going to see the child the same amount of time. It's just going to be in bigger blocks of time. And then there's other opportunity to reduce the conflicts was my proposal to designate our legal custody rights so that she would have legal custody in one area and I would have legal custody in the other. If she would have done that, that would have once again been less exchanges. So this is one of the things that I've told my viewers is don't pay attention to what they say. Pay attention to what they do. By all of my ex's actions, she has indicated over and over again that she wants to maximize the interactions with me. Not minimize them, she wants to maximize them. She was not even happy with those other 2 things that I mentioned. She even wanted to include right of first refusal, which would have increased the interactions even more. So she's saying right now that she's stressed out, or at least her attorney is saying she's stressed out and she doesn't know what to do when she sees me and the interactions are horrible and all this stuff. But by her actions, she is doing everything in her power to not only continue the number of interactions that we have, but to increase them even more. This is one of the biggest red flags of a high conflict child custody parent. Is a parent who claims that they are stressed out by all the interactions, yet they do nothing in their power to reduce the interactions, and in fact, they do everything in their power to take those so-called terrible interactions and multiply them.
There's domestic violence at the...
All right, well, you file a motion about that. We're not here about that.
But
We're here about whether or not your client transmits the child's homework packet with the child.
I understand that, Your Honor. What I'm saying is, as a matter of background for the court, I believe that Ms. Farrar does not mean to, never intended not to get the homework, but any interaction or anything like this where Mr. Falcone is involved, she sort of becomes discombobulated.
You're going to convince me to hold your client in contempt. She isn't even present. All she needs to do is tell somebody else, not him, make sure you give Dad the homework folder.
So you see how this judge is so frustrated? He even slammed his hand down. He's so frustrated. All she has to do is this, and this, and what's so hard about it? And he hasn't figured it out yet. That's why he's frustrated. That's why he doesn't know how to do his job. He hasn't figured it out yet. She's doing it on purpose. Get a clue. If you sit back and you pay attention to the facts of the case and you read the documents, you will realize that none of this is an accident. And then you don't have to stress out anymore because this is a very simple situation, Judge. This is a person who is doing this on purpose. What's the solution to that problem? Contempt of court. he's stressing himself out because he feels like he's got two sides who just can't come to an agreement. And he thinks that one side just doesn't take it seriously and she's making all sorts of mistakes and she's trying her hardest. And that despite all of her tough efforts, she is here in court now because she's not responsible or she's neglecting her job. No, none of that's true. Pay attention to the evidence because the evidence makes it crystal clear, especially if he would just look at the emails. The emails are what have her dead to rights. There's no need to be frustrated with a person who is doing exactly what they intend to do, which is exactly what she did. So now that you know, let's just assume that this was a judge who understood this, you could just do your job and hold her in contempt of court and move on to your next case. This is a clear-cut case. This parent had an order. This parent violated the order. This parent violated the order on purpose. This person is in contempt of court. Sanction, case closed, move on. There's no need to be frustrated. When he tries to overanalyze things or overread or even just taking these things at face value is silly. Don't listen to what the witness is saying. Pay attention to what the witness has done. Heed what people do, not only what they say, for deeds will betray a lie.
Well, actually, the homework folder is going with the child.
Yes, and she's sending the child with a third person because she doesn't want this tension. And she doesn't ensure that that third person transfers the homework file.
Your Honor, I don't think that it was ever Ms. Farrar's intent not to get the homework to Mr. Falcone. I sincerely believe that. I will tell the court...
She has an affirmative obligation to make sure that it happens.
In Your Honor, we have spoken...
She didn't intend to rob the bank, but she left with all the money. You know, she...
I understand, Your Honor. I would tell the court that I believe that in her defense, she's not sitting at home rubbing her hands together saying, gee, I wonder how I can violate the order.
Ma'am, I want to hear from you. Why haven't you been more careful to make sure that the homework packet gets to Dad?
Your Honor, if I have it on the seat next to me and I forget it, how else can I...
Ma'am, you explained that once, but then you said, hey, I'm too tense, I can't even be there. I'm going to send somebody else with the child to make the transfer. So what did you do? Stop talking until I finish the question. What did you do to guarantee that that person was going to transfer the homework file?
I stopped having them drop him off and I took care of it.
All of this frustration from both sides is a complete waste of time because... even if the third party had actually forgotten to give me the homework packet, which I don't think is true anyway, I think she just didn't give it to them. Even if that was true, she could have just worked around it anyway. If you just read the emails, Your Honor, you'll see that a number of options are available to her to work around a violation. Whether she forgot to give me the packet, whether a third party forgot to give me the packet, doesn't matter. She could have forgot to give me the packet and then said, here's another way we can deal with it. Or, you know what, I'm afraid to go to your work, so here, I'm going to just drop it off at the school. He's going to miss one day of homework, but whatever, at least he won't miss all 3 days. It's something. At least it's something. But that's why we're in court today. It's because she didn't provide the packet and she deliberately did not rectify the situation. She wanted to sabotage his education. She wanted to violate the court's order. If you pay attention to not only the violation, but her conduct after the violation, then you will see, it will become abundantly clear to you as a judge that this is a person who is doing it on purpose.
I'm not having anyone else drop them off now.
Well, when you were using that person,
I stopped when that was happening.
What did you do to ensure when you were using that person?
Besides freaking out at
Stop,
them?
please. Just one of us at a time. What did you do to ensure that that person knew how important this was? You're telling me, and all your paperwork and your lawyer's telling me, this guy will bring me to court on the smallest thing. I'm asking, what have you done to stop the smallest thing?
And I'd love to know how not 1, not 2, not 3, but 4 violations, at least that I can prove, probably closer to 6, 7, or 8 violations. I'd love to know how that's a small thing when the child is getting D's and F's.
I stopped having someone else drop him off.
All right. Okay, I asked you 3 times. You kept talking every time I did, so maybe you didn't hear the question. What did you do to make sure that that person that you did use for a while transferred the homework packet?
I yelled at him. I was like, don't you understand how important this is? And because they couldn't do it because it happened more than once, I stopped having them drop him off.
So you told him in advance this is really important, and you just picked somebody who was irresponsible.
I wouldn't think... What else could I do but stop having them drop him off?
I don't know. Did you tell them in advance how important
Yes.
it was?
Yes, I did.
Okay. Mr. Falcone, what do you want to say?
Before I address all of these issues they've raised, I just want to say, if Farrar violates any order, whether it's forgetting to drop him off, forgetting to give me the homework, I don't care what the order is. If she violates it but then rectifies it after, I will absolutely not file a motion. If she doesn't give me our son and there's a problem, I'll volunteer another day or time. If she forgets the homework, she can get it to me any other way. I don't like this procedure. It's very tense. I don't like stressing her out. I go out of my way even sometimes to...
Sir, I don't
with
believe
it.
this, so
Okay,
just go ahead
I'll
and
go
tell
ahead.
me what you have to say.
If you go to...
I mean, the way that you
Okay.
litigate this case is stress-inducing, and if you're telling me you don't intend it, it's like Mom saying, hey, I don't intend not to
Okay.
give you the paperwork, but if
Okay.
after a while, what you do is who you are.
See, this is interesting here. When it comes to something that the judge doesn't like, which is apparently more work for him, all of a sudden he pays attention to the actions and he doesn't really care about the words. But when it comes to all the other stuff, well, then the words are apparently good enough. But I'm the guy that's filing too many papers, so I guess my actions speak for them. You know, this is actually probably the point in the proceedings when I decided that what I intend to do really doesn't matter. Because at some point in the process, I just stopped caring. I just decided I don't care what the judge thinks of me anymore. I'm just going to force him to do what he's supposed to do because he obviously doesn't care what I'm trying to do. So if he is going to respond to the use of force like my ex, and then this is the point in time where I start to file appeals and win. Anyway, I did want to mention at least one thing here. It was good for me to at least preface this with me allowing my ex to work around a violation, but I didn't need to go so much into my intent anyway, even with the judge who does care about the intent of the litigant, which most of them don't. It's better to just stick to the way the machine operates. And if you want to know what I'm talking about, watch the video, The Machine. The court is here to take your arguments, to convert them into some kind of decision, and to spit those decisions out. And that's why you go to court. You don't go to court to look good for the judge, to get the judge to think that you're a good person. All that stuff doesn't matter. They're not going to remember you anyway. In fact, I explained that in the video. The judge does not remember you. So it is good for me at this point in time to explain to the court that it's not really the violations that justify her being held in contempt as much as it is her conduct after the violations and her failure to rectify the situation after the violations.
If you go to opposition to motion for order to show cause that Farrar filed, there's an exhibit attached. She mentioned that she was going to scan me the homework, and then I said I didn't want it. An exhibit for...
Why did you say you didn't want it?
I didn't. That's what I'm about to get into.
Okay.
She says, I say to her, I know you said you would send a scanned doc of Army's homework, but once I get off work, I no longer have access to a scanner. She responds, okay, well, you somehow managed to print up all sorts of court documents, so if you don't want
Sir,
to...
let me understand that.
Right.
You don't need a scanner to print. You don't have a printer for your computer?
Oh, no, I don't have a printer. That's what I meant. I misspoke in the email.
You don't have a printer?
Not at home. At work, I do.
Well, you need to get one.
So I've often told people, especially viewers that come to my channel, that these judges are out of touch with reality. And this is a perfect example of a judge who's out of touch with reality. He expects me to just go up and buy a printer. He doesn't understand how much money some people survive on. And for people who are working in retail for minimum wage, $9, $11 an hour, $12, $13 an hour, but don't have full time. So what I tried to say there was people who are in a minimum wage job working full time, or maybe somebody who's like working $13 to $15 an hour but only has a part-time job. We can't just go and buy anything we want anytime we want to. A lot of times people who are in those situations like me will find ways to work around not having the stuff that other people have. And one of the common ways that people who don't have the money survive on not having a printer is they print at work. They print at FedEx when they need to. They find other ways to get documents printed. They'll ask a friend. This is not that unusual. And his attitude is, oh, well, you need to get one. Like any of us can just go and get a printer. Like any of us can just go and get an attorney. Like any of us can just come up with the money to get new cars. And this is the stuff that people like this judge do not understand. They're tone deaf. And when you're trying to deal with a judge like this, you often run into issues like this where they make statements that are completely unreasonable because they don't understand what it's like to live in your shoes. They make six-figure incomes. A lot of these judges didn't even start out poor. Like I'm not going to say that they started out with all the money that they have now that they're, 50, 60 years old, but they oftentimes went from 18 straight into college, graduated at 22, went straight into a career, and they don't understand what it's like to live the way that a lot of us have to live, where we don't have college degrees, where some of us don't even have diplomas. There's a crisis going on right now with coronavirus, where people are struggling to get their unemployment because they can't even log into the system. They don't have computers. Not just like 1% of people, like 5, 10, 15, 20% who are trying to connect through their phone because that's the only computer they have. And so remember this statement, if you're ever wondering why a judge or why government officials don't understand the plight of the common person, it's because they think that we can just go out and buy this stuff.
In our society these days, people transmit things electronically.
Right, I wasn't saying I didn't need the packet. I replied to her saying, just send it before 5 p.m. so I can print it at work. This is on a Thursday. I could have still gone to work and printed it on Friday, even if she sent it late. What I'm saying is that if I was going to tell her, don't send it to me because I don't have this or that, I would have said, don't send it to me because I have this or that. All I was saying was, please send it before Friday at a certain time.
I try to be nice, but the only way that I can really actually insert any comment here is this idiot doesn't even understand that I am saying I need it to be sent to me not today by 5:30, tomorrow by 5:30, like an entire day later. And he was just kind of grilling my ex for not listening to him when he doesn't even listen to me. So he himself doesn't want to be talked at when he talks at the litigants.
Because that's when I'm here. It's 2 days. I'm trying to work with her. I'm not saying, you didn't give me the homework packet, I'm filing a motion, I'm trying to get you in jail. I don't want to do that. I don't want to put our son's mom in jail. I just want to be involved. She mentions that
So again, the emotional response is obviously, it makes sense why I have it. And I think that it's better to just come to the realization that most of these judges don't care what your intention is. And the reason I say that is because it'll make you less emotional going into court. If you go into court thinking that you want to look a certain way to the court, when you don't look that way, it messes with your head. And this is one of the reasons why I did the video of the machine, because it's really important for you guys to win your cases to remove all of the extraneous stuff from your head. The stuff that doesn't matter, just take it out of your head and treat the court process like a machine, which is what it is. And one of the first ways that you can get yourself to get on the right track is to just look at yourself in the mirror the day before court. Look at yourself in the mirror and tell yourself, I'm about to go into court, and this judge could care less what I'm trying to look like. Since the court does not care about my intentions, I'm just going to focus on presenting legal arguments, running it through the machine, and waiting to see what the machine outputs. If you can get your mindset to transition from thinking that the judge cares about you to realizing that the judge doesn't care about you, which I don't care what other people say, attorneys, they don't care. They have they have multiple thousands of cases in front of them. They'll try and say that they care. They really don't care. Stop thinking about that. Stop listening to those attorneys. The court doesn't care. Treat the system like a machine, because that's the way that you're going to actually start to see some success. And that's the way that you're going to actually start to be able to better focus in court and calm down. This is a court, just like any other court, that is way too busy to concern itself with the intentions of the litigants. They need to hear your legal arguments. They need to make conclusions of fact, conclusions of law. They need to dispense justice and move on to the next case. It's a machine. It's a conveyor belt. It's an assembly line. Tell yourself that in the mirror before you go to court so that you can focus on what you need to do to get the order that you need to get from the court. And again, that's what I talk about in the video, the machine. What's going to be the point of the hearing is the order that comes from that hearing. And the other thing that I want to mention is, even though I don't want to put my ex into jail, that is the only thing that's going to stop her. And ironically, I have stated that this is probably the thing that would have prevented her from losing her parental rights. If the court would have just jailed her for even 1 or 2 days, it is very possible that she would still have her parental rights today. But because the court doesn't do that, it never happens, and she just gets worse and worse until her parental rights have to be terminated.
She mentions that these missed homework packets were because a friend dropped him off. At least 2 of those violations, it was her, and my witness who's outside can testify to that. She mentions that I didn't want to work with her on the teacher acting as an intermediary between us for the homework packets. This was discussed in court. The court heard that argument, and the court rejected it. The court stated, that's not what we're going to do. We're not going to involve the school unless we absolutely have to. She knew not only that I was opposed to it, but that the court had ruled against it, and that's in the minutes of the hearing. I can get that if you need that. So that argument about me not wanting to work with that the intermediary teacher it's no good. And if she had, if she had done that, I still, even though it would have been against the order to do it, I would have still just gone and got it. I would rather just get the homework packet than file motion after motion. I think I'm going into the medical contempt motion now. I think this is what I wanted to get here. So, Farrar mentions that I'm rude and this and that when I'm asking her to comply with orders. After she gave me 11 hours notice to go to the first dentist appointment, and I missed that appointment, here's what I said to her. It's not, I'm going to contempt you, I'm mad. This is what I said. Short notice is okay in case that's an emergency, but please use the phone or get Robbie to text me.
He says that the reason that you got 31 minutes is because there was a scheduled surgery.
I'm going to get to that one in a
Okay.
second. This is the first one. This is me talking to her in advance. It's an emergency, but please use the phone to text me because I got this email in my spam folder and I ended up missing the dentist appointment. Email is not a good way to communicate when it comes to urgent matters. How would you feel if I emailed you about Army's last ER visit and you didn't get it until hours later? That's why I texted you or your intermediate, and that's how you were able to show up and make sure that things were good at the ER visit. Please give me the same respect I give you in urgent matters.
Okay, I want to mention one more thing. So I mentioned the emotional angle previously on thinking that the court cares about what your intentions are and why it was necessary to remove that. I also want to go ahead and take this opportunity now to get people to understand that your ex could care even less in the court. If you're going through a high conflict child custody situation, your ex doesn't care about what it is you're trying to do. In fact, most likely they know what it is you're trying to do and they're deliberately trying to piss you off. So if you can get that out of your head as well, that's just one less emotional component. Taking the emotional components out of how you participate in the court process is part of succeeding in representing yourself. You just have to do it. And it doesn't hurt to remove these things if they're not true anyway. So, I mean, it would be one thing if the court actually did care and you remove that component from you, but the court doesn't care. And the same thing for your ex. If your ex did care about what it was you were trying to do, yeah, it would not necessarily, I mean, there would be some trade-offs then to removing that from your head. But they don't care. I mean, these are high conflict child custody exes. In fact, most of them are sadistic, and they actually do care, but not in the way that you think they do. They care in that they derive some sort of perverse satisfaction from your suffering. So I talk about that in the video, Hide Emotions from Abuser. So again, the emotional response is understandable, but it's not necessary, and the first step to removing that unnecessary emotional component is coming to the conclusion that not only does the judge not really care about what it is you're trying to do, but neither does your ex. And so this is what's going to help you transition from trying to get these other people to understand your perspective, because they don't care, to getting these people to understand the use of force, because they do care about that. Your ex does care about an order commanding them to do something. the judge does care about a Supreme Court order overturning their decision. These things they will respond to. What you're trying to sort of present yourself as, they won't. They just don't care. So try as much as you can to watch the videos on the channel, because they're going to get your mind in the right place so that you can start to actually win your child custody proceeding. And it's no coincidence, guys, that as I get further on into the process and I come up to these conclusions, as I come to these realizations, it's no coincidence that I actually start to win. So I know that what I'm saying sounds bad, like, oh, Alex is saying to not be emotional, to become like a robot almost, and that's what works. Your kids who are going through an abusive or neglectful situation need you to get them out of the abusive and neglectful situation. And if that means that you have to come to these terrible conclusions to transform yourself into almost a legal machine so that you can win and pull them out of that terrible situation, then that's what you need to do as a parent. If your ex doesn't care about what you're trying to do, but they do care about a court order, do what it is that they care about to get them to knock it off. If your judge does not care about your perspective or your approach or your intent, but your judge does care about an order reversing, go and get orders reversing. Speak to these people in the language that they understand. A high conflict child custody ex will respond to the use of force. A district judge will respond to the use of force. It's what works, and it's really sad, but that's the reality. When these large corporations go out there and they file appeals and they get orders reversing or vacating the erroneous decisions of these judges, do you think they feel bad about it? No, they know it works, so that's what they do. So we as parents, who are also entitled to using the court system in America, are also entitled to getting Supreme Court intervention and getting these legal mistakes fixed. In any event, I'm going to go ahead and continue on now, but these are terrible conclusions that all of us have to reach if we're going to continue to represent ourselves, because that's what works.
I'm asking her to give me the same respect she gives me. She had this in advance. She did it again. 31 minutes notice the second time. Didn't call me. I missed another appointment. It's not an accident.
What you're saying is that, let me see if I understand. The 31 minutes is okay because she said, hey, look, it was a pre-surgery thing. They called at the last minute. She just had a, you're complaining about the way she communicated
I'm saying
with
if
you.
she violates the court's order because she can't give 14 days notice, at least do your best to comply with it in some way. At least find some way to make it right. If there's an emergency and you can't comply with 14 days notice and you set an appointment and you let me know by phone, I'm not going to file a motion. We have an emergency situation and you told me. But when you do that the first time, I give you the benefit of the doubt. I send you an email saying, please don't do this
You
again.
don't make the
Does it
rules.
again.
So he says, sir, you don't make the rules, thinking that I just came up with that on my own. That's actually the Supreme Court of Nevada that says that. When you violate a court's order, the portion of the analysis that goes into what justified the court's violation does look into the good faith of the person who's violating the court's order. So he's got this attitude. It's just going to get worse and worse, and he's going to start to say things that are even more inane than you have ever seen him say in pretty much the entirety of the My Docket series, because he's going to start to pretty much nitpick at the fact that an appointment was set within 30 minutes and I didn't get to go. But this is the kind of stuff that you have to deal with when you get into the family division, because there are judges like this who have this attitude that the rules don't really come from anywhere but themselves. And I think that's where he is about to go. I mean, he's going to basically say, where in the court order does it say that she has to do what you're talking about? He doesn't understand anything about the Nevada revised statutes or the court rules or the Supreme Court of Nevada, because the guy's hardly ever appealed. So he's just become a law unto himself. So he thinks that this is just something that I've just come up on my own that my ex should just comply with. And he probably hasn't even read the briefs to determine what is consistent with contempt of court and what is consistent with the portion of the analysis that goes into how somebody justifies their violation of a court's order.
Is there an order that says how she's supposed to communicate with you?
Email. Your Honor.
It says email, so I suppose
Then that's the rule.
Okay, so then
Did she communicate by email?
she did.
Then if you want the
31
order
minutes
changed, we can talk about that. But if she complied with the order,
Right.
she certainly can't be held in contempt for it.
Okay,
He's wrong, but I'm not going to go into it.
I requested in the alternative that we do that.
You don't get to do it.
No. I mean, in the motion, I actually requested in the alternative that we.
Okay. But you're asking that she be held in contempt, and you're telling me she complied with the order.
Okay,
Okay, what?
it wasn't compliance to the order because it wasn't within 14 days.
So was her story
Oh, no,
about there's a
I-
surgery going to happen on Wednesday, they're telling me we need to get in right now, and she gave you as much notice as there was?
I got what you're saying. She complied with the communication method of the order, the email,
Okay.
but she did not comply with the
So
time
should she
notice.
have postponed the surgery that was scheduled for a couple of days later so she could give you 14 days notice for a preoperative meeting?
Well, the law allows for, if you violate an order, to have an excuse, but at least explain.
Sir, answer my question.
So what he's doing is actually illegal. So I'm trying to actually put forth an argument, and he's interrupting it and trying to change my argument. He cannot do that. The statement that I made was consistent with the law. I stated she was in noncompliance with the court's order, but we're trying to figure out whether or not her conduct is justifying the noncompliance. He is trying to transform my argument into a different argument that he thinks is a losing argument. He's not listening to me again, he's just talking at me. And this is something that judges are not allowed to do. They need to let you present your argument, and then they can either accept or reject it. They cannot transform your argument into something you never intended it to be.
No.
Was she supposed to cancel the surgery so that she could give you 14 days notice of a preoperative meeting?
No, that wasn't. No.
Was that an emergency?
That was an emergency to me, yes.
Okay, so did she comply with the order in an emergency?
Yeah.
Then why did you file something that said she didn't?
Okay, so that was probably the most disgusting thing that this judge has done since the entirety of the My Docket series, and I don't think he tops it. I think that's pretty much what takes the cake. Never let a judge transform your argument into something else, and never let a judge coerce an admission from you. Do not do that, because then they can use that against you as a weapon to sanction you. What I should have said was, no, Your Honor, I made my argument. If you want to reject it, go ahead and reject it, but I am not changing it. She violated the court's order. She failed to justify the violation. And if you don't agree, you can make a ruling on that. But I am not going to change my argument, and I'm not going to make an admission that you've just stuffed into my mouth. Super inappropriate, and I don't think that that's something that is even consistent with the judicial canon. What I mean to say there is he may have even committed a violation of the judicial canons.
I said that she didn't because, in my opinion, she didn't. The court order said that she had to provide 14 days notice. She didn't, and if she would have...
Wait. In this circumstance, should she have canceled the surgery to give you 14 days notice, or was it an emergency?
So once again, he's trying to create two paths where there is a third. He's trying to say, since there was not a violation of the court's order, you're saying that she should have just canceled the appointment. He's not listening. Once again, he's doing... Well, I guess it's possible that he is listening and that he is, with some sort of insidious intent, trying to coerce me into that other path, which is that she either schedules the appointment and doesn't give me any notice at all, and screw you, you don't get to go, or she does schedule the appointment at a later date and the child suffers. This is the kind of stuff that I think that high conflict child custody exes will do, or personality disordered people. So when the judge does things like this is what makes me make statements to you guys that sometimes it feels to us like the same tactics of abuse, for example, gaslighting, triangulation, that kind of stuff that is used by your ex is also used by the attorneys and the judges. And that is, this sort of back and forth between me and the judge for the past 2 or 3 minutes is very consistent with the type of abuse that my ex was committing in the middle of the relationship.
No, it was just that she should have notified me so that I could have gone.
Sir, there's 2 parts to this. There's a communication method and there's the timing.
Right.
Is it your argument that she should have canceled the surgery so that she could have had the pre-surgery meeting and give you 14 days notice of it?
Well, I suppose so.
Yes or no?
Yes.
Yes, it was a violation.
Yes, it was a violation of the order as it
Okay,
was.
so she should have canceled a scheduled surgery. A few moments ago, you agreed that that was an emergency, and now you're saying it wasn't.
Right, but she didn't contact me telephonically. Then it would have been fine.
Okay, wait. We're going to do the communication method next. We're
Okay.
doing the timing first.
Okay, this is starting to piss me off. There's no way an attorney would put up with this. There is no way that an attorney would put up with what he's doing. An attorney would immediately stop him and say, Your Honor, I've made my argument, make your ruling, and move on. And honestly, they'd be thinking in their own head, they'd be thinking, how dare you?
Okay, so you're saying that her obligation under the order was to cancel a scheduled surgery so that she could give you 14 days notice of a
No.
pre-surgery
I
meeting.
understand what you're saying. No, that I prefer that it got scheduled as soon as possible.
Okay, so you don't have a problem with the timing. Okay, and then on the communication method, she did what the court order required, didn't she? She didn't do your alternative, but she did what the order required, didn't she?
Right, a 31 minutes notice of by
Okay,
email.
if
yeah.
she complied with the order, then there's no basis for contempt. If the order should be changed, we can talk about that,
Okay.
but it's not a basis for contempt.
Okay, okay.
You not liking it doesn't make it contempt.
Okay, okay. I'm not sure about the parent coordinator thing. I'd rather the court not order until I look into it, just so I know what it's about.
This is the best instinct any of you can ever have. If something gets dropped on you in the middle of a hearing without notice, just do that. Just say, hey, let me take a look at it first. Don't just agree. Most of the time, I think non-attorneys will just agree because they'll want to look good. And they'll want the judge to think, oh, that's nice. They are actually wanting to go along with some things. Don't do it. Please, don't ever, ever do that.
The Family Wizard, it sounds good, but my main issue with this, the email is fine if it's, in advance. The Family Wizard, we're going to have the same problem. If there's some kind of emergency, she's going to send something to my Family Wizard, and if it's within a tiny bit amount of notice, I might not be at the computer, I might be at work. The issue is when there's emergencies, to please contact me telephonically so I can go. So the Family Wizard won't solve that issue. She's claimed that she sent me some. Oh, wait, I see. And I guess we're leaving the child support for last.
Sir, I've invited everybody to talk about everything they want to, okay? And I haven't put any restrictions on
Okay.
what's first and last. If you want to address it, you may.
Okay. I believe that based on the financial disclosures on file, we probably can come to an amount if we take the 18% of both incomes, offset the amounts, and apply both deviations on both sides for the medical, dental, and vision benefits. The only thing I would ask is the upcoming dental appointment is $6,400 approximately, and what I was going to get married June 6th of next year, but instead we got married a couple of weeks ago to trigger a change of life, whatever they call it, to try and add him onto my wife's dental and medical to hopefully bring that $6,400 down to something really small. So I would ask that either we wait to find out what those deviations are or sort of see if we can settle. Maybe
Sir, at the present time, I'm inclined to deny your motion based upon willful underemployment. I understand your argument that you're a full-time student because, or more of a student because that's what you want to do, and that takes away from your ability to earn an income. I'll share an example with you. I'm working on an advanced degree right now, and I come to work every day.
Okay. I have a response to that. And mainly it's based on Miniar, where the Supreme Court said, we're mindful that NRS 125B.080 subsection 8 requires an additional finding that the parent's willful underemployment be for the purposes of avoiding an obligation of support for a child.
Sir, I'm familiar with the case. It raises a presumption
Right.
that if that there's willful underemployment here. What have you got to rebut it?
What I've got to rebut it is that the willful underemployment, that finding of fact is separate from, it's a separate and distinct analysis of the purpose of that willful underemployment. I've provided transcripts of my education. I've provided the number of credits that I have, and that right there belies the fact that my purpose of underemployment is just to avoid child.
Just because you have an explanation doesn't rebut the presumption. You could say the reason that I don't have a job is because I've decided to go on vacation in Europe for 6 months.
Right.
Okay, or I've decided that, anything. I mean, another explanation doesn't rebut the presumption.
He's wrong. He's completely wrong, and if I would have gotten that appeal to get in front of the Supreme Court, he would have been reversed. It's really disappointing the way that he defeated my appeal. He took advantage of the fact that I didn't have enough money to pay the filing fee, and he was able to get it dismissed by refusing to give me a fee waiver. One of the tactics that he used that basically makes me think he's more of a politician than a judge, because he's got that win-at-all-cost mentality that I think, well, attorneys and politicians have, and I guess judges are attorneys who got elected. So really disappointing, but we'll talk about that more when we get into the actual appeal itself, and I'll explain how both he and the particular justice that denied the motion were able to frustrate the attempts that I made to get that issue before the Supreme Court.
But if I see what you're saying, but I've attached the evidence that proves that I'm in actually those educational programs, and the best interest of the child standards the court should look into whether the education will improve our child's income. That education with that degree will improve
Why
my
don't you
income.
go to school at night? Why don't you go to school
There's
on
no
weekends?
night.
Why don't you go to school so that it doesn't interfere with your earning
Okay,
capacity?
the University of Nevada.
Your child needs to eat now.
I could explain that. The UNR.
Okay, so he is screwing up statutory construction here. He thinks that just because he thinks the law should work a certain way, or just because he thinks that policy is favored by his interpretation, that's just how it's going to work, and that's not how it works. The Supreme Court of Nevada has stated that a judge has to interpret statutes a certain way. If the statute has plain language, the judge has to comply with that plain language. If the statute has ambiguous language, there are other rules that apply. Just because the judge doesn't agree with the language of the statute doesn't mean the judge can ignore the language of the statute. So his argument of, well, your kid's got to eat, that's an argument that is presented to the legislature in front of a body of lawmakers. He's not there. He's in a courtroom. The legislature already considered all of these arguments. They had a debate. They went back and forth, and they fashioned a statute. And that statute that they fashioned is how they decided the public policy of this state on child support for purposeful underemployment should be treated by the courts. He is the judge. He is to comply with the command of the legislature and interpret and apply that law as they intended it to be, applied. He can't just sit down there on the bench and say, well, I'm going to say that this is how it should work. And so screw the law and screw you. I'm going to make you have to impute your income because your kid's got to eat. Anyone can say something like that, some populist statement like that. And I talk about that in the video Policy versus the Law. A lot of times when it comes to these laws, there are 3, 4, 5, 6, 7 different statements that are all true, but they can't all win. One of them has to prevail over the others, and that one becomes law, and that law must be adhered to by the judges. If judges will not adhere to that law, the Supreme Court will overturn their decisions, and I think the public should purge them from the bench, but that's a separate statement. In any event, what he's stating is in violation of statutory construction. If you want to look at the video Statutory Construction, you can go ahead and take a look at that video. I explain why judges cannot do what he is doing right now. I think, to quote the Supreme Court of Nevada, policy arguments are unavailing in the face of an unambiguous controlling statute, unquote.
Does not have weekend or night programs. Once you start getting into 300, 400, 500 level classes at the very end, that stuff doesn't exist.
Sir, I'm
It's
taking
all-
700 level classes at UNR, and I managed to fit them into my job.
In the College of Engineering, they don't have them there.
Okay, so I mentioned I was going to talk about earlier whether or not I should have objected to dealing with this issue right now in court. I'm going to go ahead and say that I should have objected to it. The reason why is because when I went into court, I think I thought the judge was going to be reasonable and he was going to apply the law, number one, the way he was supposed to, and number two, objectively and fairly. And he's not doing that at all. In fact, he's trying to find reasons to deny the relief I'm requesting. And what he's doing right now is pretty consistent with what I talk about in the video, meta rulings. So my ability to win this appeal is compromised by the fact that I didn't have that professor commanded to appear in open court and testify on my behalf. So I think that in hindsight, I have a better answer for you now. I should have objected to dealing with the child support issue today, and I should have demanded another evidentiary hearing. And at that evidentiary hearing, to win, I would have needed to command the professor who signed the affidavit to appear in court and testify. And then that professor could have answered my questions. And then I would have been able to overcome the presumption. And then if the judge refused, I would have been able to win on appeal. I know I talked earlier about the fact that he took advantage of my poverty and the fact that I couldn't pay the filing fee to defeat my appeal. So I guess that would have gotten in the way of it anyway. But let's say theoretically it didn't. The fact that I didn't have the professor there to testify on my behalf makes it really tough for me to say for sure that I would have won that appeal. Because what this judge could have done was he could have entered a finding of fact that he didn't believe me. So he could have stated something like, Alex could have gone to school at these various different times. And then I possibly would have lost my appeal on that basis. I don't think he goes in that direction. I think he just concocts his own interpretation of the law, which isn't true. And so I could have probably still won on that. But in hindsight, I did want to give you guys a better answer. So yeah, I think I should have objected, demanded a separate evidentiary hearing, had the professor appear at that hearing and then testify in my behalf in my favor. Sometimes you're just going to have to deal with judges. Actually, I shouldn't even say sometimes. You should just err on the side of caution and assume that the judge is going to try to find some way to rule against you, especially if you're a non-attorney. I talk about this in the video, self-representation bias. And so taking the assumption that the judge is going to find any reason that he can to rule against you, you want to prepare your case in the best possible way that you can, rather than thinking, okay, the judge is going to be as fair as possible, so I don't really have to bring all this stuff. Don't do that. Think the judge is going to try to screw me, and so I'm going to need to bring all of these, things, these documents and evidence. Bring them. All I'm trying to say is assume the worst so that you can bring on your best presentation possible. That's the better way to approach this case. I think that when I went into this hearing, I wasn't assuming the worst, and I should have. I should have assumed the worst, because then I would have done different things. I mentioned some of the things that I would have changed with regards to examining my ex as a witness. I think I should have also had my wife come in and testify on the stand about some of the violations. And then, of course, with regards to what I just mentioned, the child support, I should have presented as much evidence as I possibly could, because this isn't a judge who's here to be fair. This is a judge who's trying to find any reason that he can rule against me because he doesn't agree with the law that the legislature put into place. These are things that I didn't think was possible, but now I know better now that it is totally possible, and that judges are only human, and sometimes they violate the law on purpose.
It's just not, it's not a college that it flexes. Like, I don't know, I've tried to find that. I would love to do that. And my next what's it called? My next school session, I'm trying to squeeze in 30 hours a week. So
30 hours a week of work or school?
30 hours a week of work, and that's working around the school schedule. And, that shows that I'm not just trying to use it as an excuse, that I'm even working extra hours on Monday and Tuesday, that everyone else leaves at 5. I'm still there till 7.
Yeah, he doesn't care.
How old are you?
29.
Okay.
So that right there belies that. And I feel like the court's not really considering that standard. I feel like what the court's looking at is the consequence of me going to school, that she has to carry the burden and shoulder this, and I believe the words she used were finance my education.
Nailed it. That's what he's doing. He's paying attention to the consequences of the ruling, and he's ignoring the law.
But those, we have to assume that those policy considerations were done by the legislator, because, seriously, this statute, in the face of
So do you believe that any explanation for, I'm doing this because I want to go on vacation in Europe?
You see, I felt bad when I called him an idiot earlier, and then here he is doing it again. He's trying to transform my argument. Who's talking about going on vacation in Europe, dude? Nobody's saying... You can't just take an argument that you don't like, transform it into a worse argument that makes no sense at all and sounds ludicrous, and then say, well, since this ludicrous version of this other argument doesn't apply, then your argument can't apply either. Guys, I'm telling you, sometimes these judges make statements that make no sense at all, even to an ordinary person. Go to an ordinary person on the street and ask them, hey, is there a difference between a dad who's going to school full time to increase his income 5-fold and a dad who's going on vacation in Europe? And anyone's going to look at you like you're an idiot and think, are you stupid? Yeah, there's a huge difference. This guy's going to get a better job. He's going to pay way more money for his kid. That one's going on a vacation in Europe. Do you really need us to explain that to you? You're on the bench wearing robes. Do you not get this?
No.
Would that be sufficient?
No, because how does that translate to improving the best interest of
So
the
you
child?
think that what if you go to the Louvre and you have a greater appreciation of art that you can share with your child? Where's the line between what you do that's legitimately an alternative to working for monetary recompense?
I believe I suggested the court look at Trouts, because that is what they took into consideration when a parent wants to move out of state and relocate, and they have the court look at factors like a better education means better income, means better, more for the child. And I mentioned that this degree, once I do graduate, it's going to change the child support situation entirely. I'm going to end up paying her, and that's okay with me. I don't mind that. This is just the situation right now. When I have a better job because of this degree, and
What if you wanted to quit your job altogether and be a full-time student?
I love how I'm the one that's trying to get him to look at the law, and it just goes over his head. I'm like, you should take a look at Traux because they have a standard there. By the way, there's a couple of other cases, like Little v. Little from Arizona has some great insight on this. But you don't do that. He doesn't actually research case law. He just wings it. If you want to learn a little bit more about what I'm talking about, please watch my video, Wing It Judges.
That's
okay?
a whole different situation, but I would not
How's
say...
that different?
Because you don't have to do that to graduate. You could work 3/4 time.
You don't
or
have to do
part-time.
what you're doing now to graduate. You've accelerated your education.
Well, you have to weigh that. You can slow down the education, and then our child has to wait longer for a better degree to come out so that his life can be improved.
So where's the test? I mean, where's the difference between slow and complete? Where do I do that? 50-50? How do I do that?
I would say...
Well, if he's trying to actually have a debate with me, or if he literally has no clue how any of this works, we're doing it now. This is where the standards get set in the trial court, and then on appeal, they're analyzed by the appellate court. Does he seriously not know how this works? The only thing I could do really to help him along, that I guess I would say in hindsight is useful, is for me to have asserted Little v. Little from Arizona. Even though it's persuasive authority, it's a great procedure on where the line is drawn. But this judge acts like the lines just miraculously appear when they're needed. The lines are created when cases like this come before the court. In fact, this isn't even a novel case. My case of going and getting a job or going to school to get a better job, that's like a pretty standard run-of-the-mill, happens all the time type of case. Anyway, I mean, it's hard for me to really figure out right now if this is a judge who literally needs me to tell him to do his job, or if he's just trying to get me to say something dumb so that he can rule against me. I don't know what his angle is here. I hope that he does know how to do his job and he's just plain dumb, because it would be much worse if he didn't know how to do it. But with these questions that he's asking have very obvious answers that any attorney knows the answer to, that he himself should also know the answer to. But as we go further and further down the rabbit hole, things get more and more ludicrous, and I start to wonder really which way is up when it comes to this guy. And then, a lot of people have asked me, how could a judge order midnight exchanges for an infant child or a 2-year-old child or whatever? And I was like, well, this guy did, so.
I believe in Traux, they said you had to look at not only what was going to come out of it, but what the parents' intentions were, whether they were actually acting in good faith by proceeding with the education. That's kind of why I mentioned that I'm not looking to get out of child support, that if I could just get this degree and graduate, I will pay you
But let me
child
see if I understand. You've just argued that it's appropriate for you to accelerate your education and reduce your income, but it wouldn't be appropriate to accelerate to such extent that you didn't have any income. And so I'm just wondering where the line is, where the balance is.
Okay, so this is why you never let a judge transform your argument into something else, because see how he's taken advantage of that. That was never my argument. He created that out of thin air. He heard my argument and he didn't like it, so he made it about, well, what if you want to go to school full-time and not have a job at all? That was not my argument. But now that he got me to say, okay, well, maybe that's something, now he can say, oh, well, hold on a second. You're saying that you could just not go to school at all, not work at all and go to school full-time. And now he's trying to get that put into the record. And that is, again, guys, this is a dirty tactic by a crooked judge, or he just does not know how to do his job, and this is just how he debates with people. He might just naturally have this way of debating in his just ordinary relationships, like maybe with his family, wife, co-workers, and he just might take that ordinary style of debate and bring it into the courtroom. But it's not appropriate, because in court, lawyers assert arguments, judges accept or reject the arguments, and then they go up on appeal if the lawyer wants to appeal it. That's how it works. It does not work this way. Lawyers don't assert arguments. The court then takes those and transforms them into different arguments, and then discusses those different arguments that weren't even asserted by any of the parties before it's completely wrong.
That's difficult to say. In this case, if I'm going to lose, I believe it's 3 or 4 hours a week, and then you factor in that amount of money that's lost, and then you look at the salary of when I graduate, I think that's going to show that the potential amount of income, I'll earn that big chunk of money, and that should offset the small amount that I lose right now. I see what you're saying now.
I'm asking you. That's a question.
Also, the whole thing about imputing to 40 hours is not good from the get-go, because even before I increased my education. Even before I did that, I wasn't getting 40 hours a week.
Sir, you put all kinds of questions in your paperwork. What if I don't like my new boss? What if the job doesn't work out? What about all of the eventualities that could happen in life? What if some of them befall me?
So you see how the judge is using all of those good faith efforts against me as weapons? Same thing that my ex is doing. You can watch the video exploiting good faith because attorneys and judges do it too. He wants to rule a certain way. So when you're a hammer, you see everything as a nail. And so he's going to use anything that he can against me to rule against me. And this is why attorneys don't do this. Present your argument to the court and don't go any further. I know you want to look good. I know you want to show the court there's all these other examples. But now look, he just takes those and he throws them in your face, throws them in my face, uses them against me. I shouldn't have mentioned anything at all. Here's what I should have done. I should have said motion to modify child support. Here's how many hours I'm working. Here's how many hours I'm going to school. Here are the cases that control. Period. That's it. Then he can go into all of his nonsensical analysis and arguments, and I could say, okay, Your Honor, that's nice, but those aren't my arguments. I've given you my argument. Make a ruling. Let him deny it, file an appeal, get him overturned on appeal, and move on. And this is one of the things that I picked up eventually as well. And this is when I start to actually win my... So I start to go into court with a different mindset. I go into court and I don't think to myself, this is a judge who is going to be reasonable and rule, blah, 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 blah. I don't do that. I started to go into court and think to myself, I need to prepare this for appeal. And so I would go into court and my approach was very different. And I'm actually kind of eager to show you guys the difference between then and now. But my approach was, I don't even really care what this judge thinks. All I'm going to do is read all of these things into the record because I need them to be in the record. And then I'm going to prepare for my appeal. And when I started to do that, I actually started to win, just outright. I didn't even have to appeal. There was just something about that approach where I would tell the court, here are the facts, here is the law, here's what I want. If you try to change my argument, no, I'm not going to change my argument. I've given you my argument. Reject it. And then let them reject it. And then most of the time they wouldn't. They'd be like, okay, well, you win, granted, motion, get out of here. But, there were a couple of times when it was rejected, filed an appeal, won, filed another appeal, won again. And this is when I start to realize that this is I guess you could say this is sort of the third step of removing your emotions from the process. Because I talked about the first one, which is to stop thinking the judge cares about you. I talked about the second one, which is to stop thinking your ex cares about you. And then the third one, which I'm going to go ahead and tell you now, is to stop thinking that the court's going to be reasonable and fair. Just go in there thinking the worst. Plan for the worst, because then you're going to plan the best. You're going to have all of your ducks in a row. You're going to have all of your evidence ready. And you're going to think to yourself, these are the things that I need to get put into the record. You get those things put into the record, lose your case, file an appeal, win your appeal. It doesn't always work out that way, but it seems to me, and it was ultimately, the more effective way to approach going through the court process, because it's just, you know what? The machine. It's a machine. That's what it is. And again, if you haven't seen it yet, it's a great video. Please watch The Machine, because that's the closest you're going to get to understanding how this system operates.
Well, I'm saying if you're going to ask a parent, that if you're going to tell a parent that his income, he's working 34 hours a week and that he should switch his job to get a job that pays 40 hours a week, that's not necessarily such an easy thing to do. It's one thing if the parent's current job is giving him 4 or 5 hours a week, then you can kind of go out on a limb, because what's the worst that can happen? You lose your second job and you lose a little bit of income. But when you've got a job that is giving you 34, 32, 30 hours a week roughly, and then you're going out on a limb, taking a risk, trying to get another job so you can have 40 hours a week employment.
But it pays more per hour.
Right, that too. I've tried to do that, but I can't get a $20, $30, $40 an hour job until I have a computer science degree.
Well, you have a part-time, when you're only looking for a part-time job.
Does this guy seriously think that any of us can just go out and magically get the exact job that we want anytime we want it? Seriously, the last statement that he made with regards to just go out and buy a printer, that's one issue. Just because we want 40 hours a week doesn't mean that our boss is going to magically give it to us. Just because we want $30 an hour doesn't mean we can go out tomorrow and get a job that pays that much. I still cannot understand the fact that he can't seem to connect reality with what he is saying.
Well, no, even if you work full-time, you have to have a bachelor's in computer science to get a software engineering degree. Nobody will give you software engineering at that kind of income without a bachelor's degree. That's not going to happen.
Okay, anything else?
That covers the child support. I did have one question about Farrar's financial disclosure. I was just curious if the reduction in hours that she showed was something that was going to persist, like maybe there was some kind of government furlough going on, or if
I don't
it was,
believe she's asking for any change based on her financial declaration.
Oh, I mean, because it factors into, if you go with Wright v. Osborne, it factors in her financial declaration with mine.
All right. Let's come back to that.
Yeah.
I want to know from you, I want you to address everything that you've heard, but I want to know specifically, ma'am, you represented to me, I'm pretty sure, in the last 45 minutes that you offered to scan and email him the homework packet, and he said no. And he said that's just not true. He just asked you to get it to him by 5 o'clock the next business day. And I want to know who's telling me the truth.
If we pull out the email, we could just
I want to
read it.
see the email. Please draw my
Then
attention
I won't
to
be
it.
telling you what I think he said. It'll just be what
Ma'am,
he
you
said.
better be right. You're
He
in a
always
courtroom
gives
under
me-
oath. You're telling me stuff.
He always gives me a couple responses. He never just says yes, that's fine. He's like, oh, do this, but don't do that, but over here,
Well,
and
then
drop
you
it
should-
off
th-
over
listen,
here.
you sat in this courtroom and told me something. It's either true or it isn't. I want to know if it is. I've got to believe one of the two of you. And this is how I test to see who I believe. I listen to what they say, and then I try to verify it. I don't know another way.
Okay, I found it. If you're ready.
Sir, I'm talking to them right
Oh,
now.
okay,
But if you
sorry.
want to identify where the document is, go ahead.
It's opposition to motion for order to show cause filed by Farrar. It's the second to last one, not the most recent.
Okay, well, this was filed on July 12th.
This one doesn't have a file stamp. The one Kathy gave me is not stamped, so.
Then I'll wait for her counsel to find it.
So again, try to refer to your opponent's attorney by the last name as well. I mean, I was just in my 20s and I don't think I understood any of this stuff. I was pretty oblivious. But yeah, I shouldn't call her Kathy in court. I should call her Ms. Berning.
I can't hear you. What? I still can't hear you. What? I still can't hear
Okay,
you.
let me just look to see. I wonder if we could just have a moment. I appreciate your time.
Okay, my clerk has just informed me that I forgot to swear the two of you. Would you each please stand up,
I'm
raise your
sorry.
right hands, face the clerk, and be sworn?
You solemnly swear that the testimony about this matter is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
See, please. Sir, is everything you said so far true?
Yes.
Ma'am, is everything you've said so far true?
I believe so.
Okay.
Homework.
Let's see.
Just close so I can hear you.
No, it's not mine.
This is yours.
Okay, so,
Your Honor, I direct your
do you
attention.
want me to read it?
Yes, this is the exhibit number 4 on the opposition.
There are lots of motions and lots of oppositions. Could
excuse
you
me,
give me
yeah.
a date?
Yes, Your Honor. This is the, oh, gosh, here. This is the opposition to motion for order to show cause filed, let's see here, on May 6, 2013.
Okay, hold on just a second. I'll get there. This is the opposition or the replied opposition?
The opposition.
Okay, the opposition in which exhibit?
Exhibit number 4,
Okay.
I believe.
Yes.
This is back here.
All right, I'll read that out loud here.
Say that to me, says he can't do it. Because it's already-
So you say, let me see, reread my email sent before 5 so I can print it at work. Well, okay, well, you somehow
reading-
managed to print all sorts of
You're reading
documents.
it backwards, Your Honor.
Start from the bottom.
Okay, so at 4:30, Dad said, I know you said you would send a scan doc of Army's homework, but once I get off work, I no longer have access to a scanner. That's sent on Thursday. It doesn't say send it by Friday at 5 o'clock. It says at 4:30 p.m. that once I get off work, I no longer have access to a scanner. Mom responded, okay, well, you somehow managed to print all sorts of court documents, so if you don't want me to send it to you and you want me to just do it with them, then I will. I'm getting texted that you need to talk to me. I'm I am not by a telephone other than my personal one. What's going on? And you said, sir, responded, reread my email. Send it before 5 p.m. so I can print it at work. Sir, you told me that you told her she could send it by 5 o'clock the next day. That's not in this email.
That was the verbal.
This is basically
When she didn't have it on that day, we talked that all out. We already knew what was going on by here. And then she said, "I'll send it to your work," and I said, "Thank you," etc. 5:30, all that. And then I said, "I know you said you'd send it."
I
but,
do know
right.
that when you said send it by 5 o'clock, that was sent at 7:20 a.m. on Friday.
Yeah, and I probably didn't read that.
So why didn't you do it?
I probably didn't read that, sir. I read the first one where he's basically saying, don't send it. And I'm like, okay, fine, I won't send it then. And I responded to him, and I figured that was that. And I probably didn't read his Friday one by Friday. And if I didn't read it until after Friday at 5, then I wouldn't have sent it to him because he said he couldn't print it anyway.
It doesn't say don't send it.
Well, that's what I interpreted it to mean.
Don't talk to each other. Again, this is just so inconsistent with your argument that he's just harassing you by picking on every little thing. And then you say, I don't read his emails. I just, I just figured it was over, and so I stopped paying attention to it, and I didn't deliver the homework package. I don't want to hold you in contempt, but you have to comply with the orders, and the stuff that you're telling me about why you didn't is unacceptable. It's not good enough. I picked somebody who didn't do what I told him to. I didn't read his emails. If it was one time, that'd be one thing, but this is happening over and over again, and your excuses aren't reasonable. Particularly in a situation where you're telling me that he's nitpicking you for every little thing. All right, what do we have to say about any of the other issues? You want to say anything about the other issues or anything more about this issue?
Do you want to say anything more about this issue?
Yeah.
What do you want to say?
I'm sorry, and sometimes when you're stressed about something, you make more mistakes than you must.
Why don't you say that then? Your Honor, Ms. Farrar wants to address that issue that you've just brought up with regard to the homework. Then there's just a couple other comments.
Please do.
I'm sorry, I tried to fix the problems. We weren't still having problems with the homework by the end of the semester. We didn't have a problem with summer school. And I'm sorry, and I'm sorry.
Ma'am,
And
your
I'm
sorry isn't
sorry,
an explanation.
And I tried to fix it. And sometimes when you're stressed about something, you make more mistakes than if you weren't stressed about it.
Anything else?
Yes, Your Honor, just on the matter of Mr. Falcone's financial declaration that he filed. Let's see here. I think that the court in page 2, that he lists his income on line 1, and as well as he lists the amount earned of $15, and then he lists some 800 and some dollars as a result. I just point that out to the court. But having said that, I'd be asking the court to deny the motion. I won't add anything else. I think the court's heard enough on that issue.
All right, sir, is there anything else you want to say on any issue?
Just in response to the... No, I think you've got it all. I would ask that you take the child support under submission, though, before making a decision. Maybe you'll see something in the guidelines under trials that talks about that balancing act. And...
Thank you, sir.
Thank you.
Trout's not a child support case.
I realize that, but we were groping around for some kind of standard, some kind of scale for this kind of.
Relocation cases are one of the few places in the law where the best interest of the child is not controlled. The freedom of the parent to move controls.
Right, there's a balancing act there.
Well, but I'm not aware of anything else in our family law where the best interest of the child doesn't control, and it certainly does control in child support cases. And that's not the critical factor in relocation cases. It's a consideration, but it's not determinate. Okay, I'm going to take a minute. Okay, I'll be back in just a few.
All rise. Court is again in session.
Have a seat. Sir, would you agree that your second motion for order to show cause covers the same issues and that it doesn't need to be ruled on separately? Or do you think there's something
Except
else?
for the alternative part that asks for an order to handle, for the most part, yes, except that asks for
Okay.
alternative.
On the issue on the first motion for order to show cause, I am so frustrated by seeing the two of you. You must be driving your child crazy. Most people, in the length of time after an original order, have settled down to a new normal, and you two haven't. And I could easily say that you're overly litigious if you would cut it out and stop doing this stuff. The explanation that you provide me is, when I get really stressed, you make more mistakes when you get stressed. If I bought that explanation, you'd never have to comply with any court order. I'm sure you're going to be stressed in the future, too. And if that was a get out of complying with the court order ticket, the orders would be meaningless. Okay? You haven't been given a very stressful assignment. Let's get them the homework packet. It means picking somebody responsible. It means not forgetting it on the seat. It means reading your email on Friday morning so you can see that he said you have till 5 o'clock today, Friday, to do it. One of those we could excuse, two of those we could excuse, three of them. It gets to the point where it's meaningless. I hate the idea of holding you in contempt because I don't want to give this fellow, who I perceive as overly litigious, something to hit you with. But I have no choice.
And see, that statement that he made is direct proof that he does make meta rulings. And that supports everything that I warn you about in the video, meta rulings, which is that judges like this don't make a decision based off of the law. They make decisions based off of what they don't want you to perceive, how they don't want you to react, how they want you to react or perceive. So he's making a decision not based on the statutes and the facts. He's just making it based on the fact that he thinks I'm litigious and he doesn't want me to win. He stated it plain as day. That's, again, something that I possibly could have taken up as a judicial canon violation. But, this guy already got dinged with a violation of the judicial canon last year, and that's probably why he's not even running for re-election. But, it's just... the statements that he makes like this show that he's not fit to be a judge. He should have probably never took a seat on the bench. And this attitude that he has, where he thinks I'm the bad guy because I'm litigious, is directly connected to why our son suffered for so long. Our child continued to suffer abuse and neglect because this judge didn't want me to win. That's what he stated just now. And the reason why he didn't want me to win is because I was filing too many papers. He doesn't care about abuse. He doesn't care about neglect. He cares about too many papers being filed. And the second that you stop filing papers, everything must be going so well for that child. So well. And again, I've talked about this probably a million times. I explained this wrong-headed approach to being a judge in the video. End of filings is not end of abuse. And so this is why cases like this drag on for 8 years, because of attitudes like this. These are the people that are sitting on the bench with this attitude about don't you dare file too much stuff, or you are the bad guy that I will want to make sure doesn't win. So I think at this point in time, I'm going to win this issue of contempt because he feels like I've put on too strong of a case and he really just has nothing else that he can do given the circumstances. But you know what? If he didn't have this approach to being a judge, if he wasn't on the bench, maybe I would have had a different judge, like maybe District Judge Bryce Duckworth, for example. There are a few out there who are just amazing at what they do. You know what would probably have happened in this case is I would have ended up with primary physical custody, and my ex would still be involved in some way today. She needed some heavy hits from the court in the beginning, and this judge, his indecisive nature, his weak approach to taking control of the case, to not taking any control of the cases at all, he is directly to blame for the abuse and neglect because he was given all the information. I will agree that it's not the judge's fault when they're not given the information that they need to make a decision. But when you do give a judge the information that they need to make the decision and they don't do it, then they have a hand in the abuse and neglect that children suffer. In any event, I wanted you guys to really highlight this portion of the video because he stated from his own mouth, from the bench, on the record, that he didn't want me to win. And the reason why is because I was litigious. He didn't want to look into why. Why did I file so many papers? That was just not important at all to him. But I filed papers, and I shouldn't have done that. That's not good.
Based on what you've done, I find that you're in contempt of court for failure to comply with the court's orders, that you had the ability to do so, you didn't take reasonable steps to make sure that you complied. I find that you're in contempt of court. Sir, what sanction would you like me to impose?
I would ask you to impose, and my solution is just because I want this to stop. I believe that no amount of money will do it. I would ask you to impose 1 day of imprisonment, just so that she knows it's there.
So there is a lot of logic behind why I asked for some incarceration. Number one, she's already paid money through the nose for this attorney. Tens of thousands of dollars, I'm sure. And the money isn't doing anything. It's not a deterrent for her. She doesn't care. And I also didn't think that she would need 30 days imprisonment. It would be in jail. I didn't think she needed that. I honestly thought that my ex did not think that she would ever see the inside of a cell. And so I thought it would be jarring for her to just have even a single day in jail. I also didn't think there would be any point to her paying any more money than she's already paid. All it's going to do is damage whatever she can spend for our son. To me, the solution to the problem was incarceration, just because she needed to know it was a possibility that she'd be incarcerated. I felt that once she knew it was a possibility that she would be incarcerated, she would stop. That's what I sincerely felt.
And so that this can finally
You
stop.
want me to send her to jail today?
Just 1 day.
You want me to have the bailiff take her into custody right now and
It's
put her in
not
jail
something
till
I'm
today
doing.
at this time
You
tomorrow?
might think I'm revenge-based, or that this is a power struggle, or that I just want to hurt her. I don't want to do any of that, but I'm telling you, from my experience in all of this that's going on, is if you don't do that, even if it's just 1 day, she won't stop.
Okay, so you want me to give her 24 hours in jail. Counsel?
Your Honor, I would ask that if the court is impose a sanction, that it be a fine. Ms. Farrar has to work for her money, and to do so, that's a pretty hefty sanction for her. And I would ask that the court do that. She understands, in my conversation with her, what she should have done, and I do believe she is deeply sorry.
I didn't get that from her at all. I got, I'm sorry. That's what I got from her. I got that she's sorry.
I would ask the court not to put her in jail. I think that a fine will have the same effect on her. Community service would have the same effect on her. If the purpose is to remind her that it's important to follow the court's orders, sometimes the idea of doing community service is much more effective in doing that, because you have to remember what it is that you're there for. And again, any time where you have money that you could have used for something else, but it's going to the court as a fine, I think that also serves the purpose. And I would ask the court, inasmuch as it's the first time that she's been held in contempt of court, I would ask the court for a fine or community service rather than jail time. One moment, Your Honor, if I may. Your Honor, what Ms. Farrar tells me is this, is that she would rather the court impose community service. Because to impose a fine, really, she's trying to get the money together to have Army have his dental work done. And what she just told me was that if the court sees fit to put her in jail, she would rather go to jail because she doesn't have the financial wherewithal to meet her needs for her son.
All right. Ma'am, stand up. I don't have any desire to punish you or harm you in any way. I understand that you're in a difficult relationship with the father of your child. Okay? I feel boxed into holding you in contempt. This is my sentence. I sentence you to 24 hours in the Washoe County Jail. I suspend all of that.
Okay, so I have to give the judge some credit here because when he did this, when he suspended her jail sentence, I sincerely thought that that would do it. I left that courtroom and I was thinking, she's scared. She's not going to do this anymore now. She thinks it's real, that she'll go to jail. Disappointingly, she, within even a day or two, went back to what she was doing before. And then I want to mention one more thing, is the judge felt boxed in, which yet again proves that I was right, that he only did this because I forced him to do it. And the sad thing is, he didn't realize it at the time. Hopefully he realizes it now, because I'm sure he knows who I am. He sent me emails before as administrator of our Nevada judges. I've gotten his emails. Well, not from him directly, from his political operatives. But in any event, I hope that now in hindsight he realizes, after her parental rights have been terminated, after District Judge Bridget Robb pretty much deprived her of every other parental right that she had, that the thing that he was boxed into doing was the right thing to do. And unfortunately, he didn't actually send her to jail. He just suspended her sentence. But even though I give him credit that that even was, to me, probably enough to get her to stop, and even though she didn't stop, if he would have actually sent her to jail, maybe she wouldn't have stopped even then. Because she herself said she'd rather go to jail than pay a fine. So maybe she would have gone, sat in a cell for a day, and just kept on doing what she was doing. Maybe she needed 5 days, maybe a week, maybe a month. Maybe she would have never stopped. Maybe termination of parental rights was the only thing that was in the cards for her. These are just some thoughts that I have. And this situation's not over. I mean, there's still a little bit more of the hearing to go. But this is the reality that was put upon me by a judge who even now feels forced to do his job, who feels forced to do what he's supposed to do, who feels that I am an evil person. Somehow, some way, filing a bunch of papers in court makes you an evil genius. For whatever reason, he just does not like self-represented people. If you file 1 or 2 papers, that's okay. But if you file 5 or 6, something's wrong with you. You must be a demented mastermind of some sort to have figured out how the court process works. You can't possibly be here to protect your kid. That's just what you're going to see with many of the judges in the family division. And it's really unfair because it's, for the most part, connected to self-represented people. For whatever reason, when you have an attorney who does the same exact thing, it's not seen that way. They just think, well, he's a lawyer. He must know something that I don't know, and he's doing his job collecting money for his business, so that's okay. I talk about this problem in the video, self-representation bias, but I really wanted you guys to connect this portion of the hearing video with all the other things that I've been telling people from my channel in the past. Is a lot of times these judges won't do the right thing unless you box them into it, unless you twist their arm. They won't do their job unless you force them to do their job. And even then, they'll do it reluctantly. And even then, they'll exercise their discretion in a way that waters it all down. And this is a problem that I talk about in the video, discretion. These are all things that I think that if we don't figure out as a society, we won't be able to fix them. And it really does start with purging the bench of these types of judges and replacing them with the judges who are actually willing to do their jobs.
On the condition that you comply with these court orders in the future, if we come back to court on similar charges, bring your toothbrush with you because you're not going home. Okay? All right, have a seat. Sir, I heard you say that you want me to take the issue of your spousal support under advisement, and I'll do that. And so then the last issue was your pending motion for contempt based upon the dental appointments, and I went through the analysis of that, and I don't hear a contempt.
Right, we were just going to do the alternative request so that we could handle emergency.
Okay, well, I hear all sorts of alternatives, and I'm willing to consider any alternative that anybody wants to think about. You want to propose, sir, what alternatives?
That Farrar's counsel and I came up with some pretty good language. We just had one dispute. That language was that the court ordered, quote, when an emergency arises and sufficient notice cannot be given, the parent scheduling the appointment shall email the other parent and shall telephone the other parent in a timely manner. An emergency shall include, but is not limited to, emergency hospital visits, scheduling of medical...
Sir, I don't want to make her telephone you. Do you get text messages?
Yeah, that's fine. Telephonic communication covers text messages.
How about text messages?
I have a personal cell phone, I have a work cell phone. I use it to answer
Your Honor,
calls.
the issue with the text messages is that Ms. Farrar only has one phone and it's a work phone. So for her to receive text messages on that, I think she believes is inappropriate. And I don't know what the policy is of the VA on those things.
Well,
So,
here's
but-
the problem that she can appreciate. He doesn't check his text messages. You didn't check yours all day Friday. You understand that some people don't check their emails. And if I said text message, I apologize. You didn't check your email from 7:40 in the morning on Friday till after 5 o'clock. I don't know if you ever read the message before we got here in the courtroom today. So you don't always check your email. So we need a more effective means of communication than that. So text would be reasonable, but if that's something that you don't have access to, what alternative do you suggest?
Your Honor, what we suggested at the time Mr. Falcone was unwilling to do was to use a third party in order to do it. And Ms. Ms. Farrar realizes that they have communicated with regard to the emergency medical care. What Mr. Falcone did was to notice the third party intermediary that they had agreed on. That third party noticed Ms. Farrar, and she got a message through the intermediary back to Mr. Falcone. So, and basically, what we would ask the court to do is to basically order that kind of communication where she can communicate with him via telephone, but through an intermediary if she chose.
So, okay, the specific example that I have in front of me is 31 minutes worth of notice. You're telling me that would work more effectively if we involved a third person?
No, Your Honor. What I'm saying is that what Mr. Falcone, in our view, is trying to do is to just get contact, direct voice contact with Ms. Farrar. If I can have just one moment to speak with her, maybe I have a resolution.
All right,
May I do so?
but let me suggest a couple of things. One is maybe the emergency contact she makes with him can be by text message. And maybe the emergency contact he makes with her, since she can't get text message, would be an alternative means.
Would you like to do that?
That's fine.
We would
But
agree to that, Your
only
Honor.
if he agrees to never call my phone or never text my phone.
What Ms. Falcone is requesting, what Ms. Farrar's requesting, Your Honor, is that, that as long, she would be good with that as long as Mr. Falcone did not text her phone or call that phone.
How does
because
she
it's
want to
in
be
the-
advised of emergencies?
He already tells me through Robbie.
Mr. Falcone already does that through the intermediary that they've decided on, which is a friend of hers.
Does that work for you? If she's going to advise you of an emergency, she'll do it by text. If you're going to advise her of an emergency, you do it through Robbie, and you never telephone her and never text her.
Yes, that's fine.
Does that work? Does that work for both sides?
What happens if he does?
That's a violation.
Does that work, counsel?
Yes, Your Honor.
Then
That
that's
he
the
would-
order on that.
Okay, never telephone, never text through Robbie,
Never give my
All
phone
right.
number out.
and that she will text him.
In emergencies.
Right.
Okay. What else should we change in the orders?
I did have one small issue with the medical one. The current order says 30 days notice of when somebody doesn't pay a bill and 30 days of the explanation of benefits. I never get those. The EOBs just go straight to her. So would it be okay if I just send the bill itself? Because there's a bill that she doesn't want to pay and there's a dispute on that. And
I think if you don't get the EOBs and you get a bill and you can send a bill and a canceled check or a receipt or some
I
other
have
kind of
that.
canceled
Okay.
proof of payment, that's what it's got to be.
she gets the EOBs, but I don't. But the order
Okay.
right now
Is that
requires-
acceptable, counsel?
Yes, Your Honor. Also, there's a matter of a bill that Ms. Farrar paid, several bills. Would it be, I'd like to be able to send those bills with those proofs to Mr. Falcone so that he can,
What has precluded you from doing that if you've got a 30/30 provision?
nothing, Your Honor. But just to have it out in open court today, that's what we intend to do. Part of this has been that rather than have contact with Mr. Falcone, Ms. Farrar has just paid the bill. And in fact, there has been an increase on Ms. Farrar's insurance from the $75 to $116 a month. But because of the litigiousness of Mr. Falcone, she has been reticent to do anything about it. So what we would like to do is to be able to present those bills, and if they're bona fide bills, we'll present them with the
You
paperwork.
can present anything you want, and if you haven't complied with an existing order, there might be consequences of that. I'm not going to
course.
prejudge it.
Of course.
And ma'am, I don't know what to say. I mean, it's your argument for why I shouldn't hold you in contempt, because you're nervous and you don't want to do things. I don't know what to say. I really don't know what to say. If you can come up with a solution that you think can be fashioned into an order, that I don't know, how, is he supposed to intuit that you got some medical bills or that your premiums went up? I don't know how you can do anything about that without communication.
I told him about the premium and he harassed me. So
I understand from my client that Mr. Falcone knew about the premium, but
he said to take it to court.
that he said to take it to court.
Well, then take it to court.
All right, Your Honor.
I mean, counsel, you can advise your client. If there's another way, and you know the ways, she can file a stipulation or she can file a motion. And just because he's aware of it doesn't change anything. What our law says in changing child support is that the court's not able to modify a payment once it accrues, except back to the date that a motion to modify is filed. So the fact that he's aware of something doesn't have any implication in the law.
We'll do that, Your Honor.
All right, what else should we address today? I'm going to ask both sides, so do you have anything else? How about this family wizard thing that you want to do?
Well, Your Honor, I just put that out for the court. I don't want to create additional problems. My thought in it was that it would be a way for the court to track what occurred, and maybe the court does not want to implement something like that. I've used it in other cases where parents have difficulty in co-parenting. They're able to use that successfully. And maybe before the court issues an order on that, I'd like to inquire, maybe I'd like for Ms. Farrar to be able to look at that first to see whether or not.
Well, he asked for the same thing so the parties can look at it, but let me
Right.
just point out what happened here today. We didn't have any trouble with the emails. Everything was here. The problem that we had is your client said, I'm reticent to interact with them because it's so stressful. Do you have anything that we can do about that? I mean, maybe we've
No,
helped a
it's
little bit by doing what we just did about emergency contact.
He's not supposed to email me except about medical and school stuff, and he sends me all kinds of.
Your Honor, I guess one thing that Ms. Farrar alerts me to is that I guess to ask Mr. Falcone to abide by the order which says that he's just supposed to be emailing her about the appointments and about something that has to do with Armando.
If that's the order, and I didn't look at that because we didn't talk about
Right.
that today, I will enforce every order that there is as it is written. And that's a warning to both of you. Okay? If you're violating orders, cut it out. Okay? If somebody wants to talk about modifying orders, I'm all in favor of discussing it. But existing orders are not suggestions.
Okay, so can I bring something up?
No, don't do that.
He didn't return to me.
We'd file that.
I'm not filing.
Your Honor, what Ms. Farrar is telling me is that there have been other times that she has not filed, she has purposefully not filed motions, and I understand the court's position. When Father's Day came around, Mr. Falcone was supposed to return Army to Ms. Farrar. He didn't do it. And so what he, as the court knows, will proceed to court to force those issues. She's reticent to do that because she's trying to get along. And so there are other violations. I don't know. She and I will talk to see whether or not we'll go forward.
She'll
with
have to
those.
follow whatever your advice is, counsel.
Exactly.
I don't know what to say about that.
No,
That's between the two of you.
Right. Let's talk about that later. The other thing, Your Honor, is I know that in other cases the court has been able, through motion practice, takes control of the case, where the party before a motion. Before a party is allowed to file a motion, that the court, it gives a court a brief explanation and of that, and then the court decides whether or not that motion can be filed. What that would do is it would save the opposition of save Ms. Farrar from having to do an opposition to a motion that may in fact not have any basis.
Well, the problem that we have in this case is he won his motion. I found your client in contempt. So if you could tell me he's filing frivolous motions, I'd be glad to do that. And ma'am, you could make all of his motions frivolous just by complying with the orders. And so there's just no basis to treat him as a vexatious litigant when he prevails.
Your Honor, are you saying that he has prevailed on more than he has prevailed
On what we did here today.
Well, are you also saying that he's prevailed on his motion with regard to the dental appointments?
No, he didn't prevail on that one.
And the court has yet to decide with regard to
Right.
child support? Thank you. You've clarified it.
Okay. I would love to come up with a way to stop the filing of motions in this case. This cannot be healthy for you two to have this adversarial relationship. This cannot be helpful for your child.
Well, he's a fool, because the way to stop the filing of motions is to actually make decisions that are in the best interest of the child. He thinks that there is some magical way that he can snap his fingers and my ex will stop doing what she's doing. He doesn't understand that his job, what he was elected to do, was to sit and preside on the bench over cases that involve child custody issues. So if he wants the filings to stop, then he needs to start ruling the way he's supposed to rule. As long as he continues to pussyfoot around the issues, to dodge the conflict, to pretend that one day we will magically just figure out how to work together, as long as he continues to believe these fanciful, ridiculous ideas, these motions will continue to get filed. And if they don't, because he's broken my financial back or because he's declared me a vexatious litigant, then I pity what happens to our child. I mean, honestly, you guys haven't even seen the beginning of what is to come, because there will be hearings that come up that shock you. And this guy, with his ridiculous simplistic view of high conflict child custody, is directly to blame for why motions keep getting filed in his court. It is literally his own fault. There have been a number of filings in this case where he had the opportunity to make decisive rulings that would have very clearly communicated to my ex what was to occur in the case. And had he done that, he wouldn't see the filings that he sees today. So here he is sitting on the bench complaining about all of the filings in the case, when he himself and his own actions and conduct are to blame for precisely the thing that he complains about.
The only thing, they've tried mediation once, and that's the only other thing, Your Honor, that I can think of is that if we had a parental coach for the two of them, but that also is can be expensive.
They're exchanging the child in the middle of the week, right? Mm-hmm. Okay. The last time we were here, I suggested to you that you exchange the child once a week.
I mean, I can almost laugh at him because what he's saying is actually what needs to occur. And he said this before, but he won't do it. He won't do it because my ex doesn't want to. My ex doesn't want to do that. Her attorney doesn't want to do that, so he won't do it. He has these instincts that actually would decrease the conflict in the case, but he does not order it. He continues to have this ridiculous idea that if we can't agree to something, he isn't going to step in and intervene, which is exactly what needs to occur in this case, because we have a parent who, due to her mental health issues, does not understand that she's harming the child. And again, if it wasn't for my ex's mental health issues, I would rest a lot of the blame on her. But she has a problem with her perception of reality. She isn't really capable of understanding 100% the dynamics of being a parent. She doesn't have a parental compass. So in this situation, I have more blame for the judge and the attorney than I do for her because they know better. And when he says something like, why don't we just go to week on, week off? That indicates to me that he knows better. He knows better. He has instincts of what to do, but he won't do it. And that's exactly what I was saying in my previous interjection, that he complains about precisely what he causes to occur through his inaction.
Your Honor, I don't think it's so much the exchanging of the child, but it's all those other interactions.
Counsel,
with
you've
regard
told
to
me that your
Armin.
client doesn't want to go, that sends an intermediary, that isn't responsible enough to give the homework, that she's nervous to go near him.
It's like suddenly his lawyer brain turned on. I don't know where it's been for the past few hours. But yeah, he suddenly notices there's contradictions in her statements. She says one thing, she says something else. They don't mix. She does one thing, she says something else, she does something else. Again, contradictions. He notices the contradictions. He notices something is wrong here, but he still thinks that she's acting in good faith. He still can't accept the truth, which is that everything that she is doing, she's doing on purpose. And that maybe I am not the evil mastermind that he has decided for whatever reason I am.
I think that if we could reduce the number of contacts, that might be a positive thing.
Ding, 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 ding.
He sends me a million emails. He says,
I think that what Ms. Farrar is saying is that there are other matters that, and we can address this through motions, Your Honor. I wouldn't take the court's time today.
She doesn't file any motions.
That Mr. Falcone sends other, in matters not before the court, sends emails regarding other things that don't really apply to being a co-parent.
All right, so we
And we can
addressed
do
that. I
those
told him to
things.
comply with the order, and you can
Right.
file a motion to hold him in contempt if you
Right.
want to.
Right.
Okay? Okay, you guys, you just said to me the same thing you said last time, that changing the schedule isn't going to help. I'll bet it would. If it would cut the number of times you guys have to see each other in half, I'll bet it would be helpful, but if it's not what you want, it's not what you
Your
want.
Honor, I'll discuss that with Ms. Farrar, and Mr. Falcone and I can email about that, whether or not that's appropriate this time, and see if there's an appetite. We can always bring that to the court as stipulation.
If you guys want to have a settlement conference as opposed to filing motions, if you come up with a list of things that you want to sit in here and talk about and shuttle back and forth, I'd be glad to do that. If I could come up with a way, I mean, I understand that I was kind of aggressive here with you this afternoon, and it's because when I read this case, it's just so frustrating to see you coming back and 2 additional motions after this one's scheduled. It doesn't appear to me that there's sincere effort to try to reduce the hostility, even though both of you say, I'm trying to reduce the hostility. Neither of you are doing the things necessary to reduce the hostility. Sir, is there anything else you want to talk about here today?
Just the Father's Day thing, since we're talking about
The Father's Day thing?
They stated that I didn't return the child to her on Father's Day. That's actually not true. But a long time ago, we started to claim vacation days attached to our weekly schedule. And whenever that would happen, rather than keep the child, or rather than drop the child off at like 10 o'clock p.m. and pick him up the next day at 8 or whatever it is, we would just keep him through. We've both been doing that. To me, when that was presented to me, it just looked like a retaliatory thing.
Okay, so this is actually true. My ex and I construed the court order a certain way with holidays, and we went along with that for, I think, years, if not for several months. And then at some point in time, probably when I filed a motion for contempt on her, she decided to change her mind as to how we were going to interpret that provision. This is actually highly relevant, and I discussed this in the video, Interpreting Court Orders. It should be a high conflict child custody video. Take a look at it, because from what I have researched, when a court order is ambiguous in some way, the appellate courts look to how the parties interpreted the provision with regards to determining whether or not you're in compliance with the provision. So the thing that's curious, this doesn't apply when there's plain language, but when there's ambiguous or confusing language and you and your ex start to interpret that language a certain way, from what I have done, from what I have researched, that particular interpretation that you and your ex have begun to sort of implement, that becomes the controlling interpretation going forward. So I didn't know this at the time, but now, all these years later, I do know this, and so I can say that there is a better legal defense to what my ex is alleging. I need to make another statement, though. A lot of the things that have been brought up by my ex were not in the briefs, so they're not even appropriately before the court in the first place. So I really shouldn't be talking about any of these issues because it's not fair. I've been able to fully brief the court and get all the evidence and such. So, like, for example, she asked to declare me a vexatious litigant. That was just out of the blue. That wasn't in any of the motions. And then now there's this thing here with regards to holiday, I guess she said Father's Day exchange or something like that. And by the way, her interpretation was ridiculous. I can't even remember what it was, but it was a nuts interpretation. It was something like I drop him off to her the day before Father's Day at midnight, pick him up that same day at 9, keep him till 5, drop him back off to her at 5-ish, 5:30-ish, then pick him back up at midnight that same day. I wish I could remember the craziness behind it, but because it was so low on my radar, I don't even remember it coming up in the briefs because it didn't. So I wish I could tell you guys more about that, but I do remember it was a crazy interpretation. Anyway, let's continue.
But maybe that should be put into an order just because it's what we've been doing for the past couple of years anyway.
I'm not sure what you said. Do you understand what you just said?
Can I talk?
Yes, that my client reports that that's not true as to what's happened. I think that would go beyond what we need to do.
Right.
Ms. Farrar did make one suggestion, and Mr. Falcone, for his part, has been professional in allowing counsel some time in filing oppositions in order to try to work things out. But maybe another thing that the court might do is require the parties to give notice of 30 days if they intend to file a motion on whatever it is, or make contact. Mr. Falcone could make contact with me to see if we could work something out prior to his filing a motion. In the past, he has worked with me when I've had other conflicts in my calendar to extend that time, but maybe if we set a time certain where we would work together to see if there could be a stipulation on whatever that issue is, and if he could flush out that issue, whatever that was, with me prior to filing a motion, that might bring fewer things to the court.
What do you think of that suggestion, sir?
I've actually already been doing that. The only thing I would object to is the specific 30-day time limit, because depending, if something is a slow matter, I'll give her months and months of notice. I'll tell her over and over and over, please help, And I just want to say that if she disagrees with any of my requests, she can always throw something back and we can work that out.
Right.
But every now and then there's something that
I'm not inclined to create a new rule of civil procedure for this case. I've awarded attorney's fees in this case. I've made findings of contempt in this case. I think the existing rules of civil procedure are sufficient.
Your Honor, I would, for my part, think that I would thank the court for being willing to schedule settlement conferences based upon a few issues coming together.
If the parties agree that we should have a sit-down on issues, I'd be glad to do that.
Thank you, Your Honor.
I'd like it better than deciding whether or not one of you should go to jail.
Thank you.
Sir, is there anything else you want to talk about today?
No, Your Honor.
Counsel,
Nothing further, Your Honor.
good luck to you both.
Thank you.
Okay, this is already a very long video, and we have a few ancillary documents. I am going to go through them very, very quickly because honestly, it's a long video already, but there isn't really much to go into. Anyway, these are the minutes entered by the court following the order to show cause hearing that we just went through. I've talked about minutes before. I don't like to talk about minutes too much because the court order that comes out afterwards is what's actually going to control not only us, through binding us, but also through like if there was to be an appeal or something like that. Minutes do not do pretty much anything. They're just like a really quick list of notes that were taken from the hearing for you to sort of keep in your mind, but really it comes down to the court order. So when the court order is entered, we're going to spend much more time on that. We're going to go through it line by line, but these are the minutes. If you'd like to go through the minutes, just like with my previous videos in the My Docket series, all you have to do is go down into the description below, click on the links, download the documents for yourself, take a look, and if you have any questions, go ahead and post them into the comments below, and I will, of course, spend that opportunity to actually respond to you on your questions. Next document is supplementary points and authorities after hearing regarding child support modification. The reason I'm not going to go through this document line by line is because I already went through this in the hearing, and I've also talked about this before in previous videos. It is a new document. We haven't gone over the document before, but everything that's in the document we have discussed. It goes through the analysis on willful underemployment. It goes through my professor having, I don't think it's entered yet, but it will be entered very soon, the declaration from the professor. It goes into night classes, weekend classes, online classes. Everything that we talked about in the hearing and prior is discussed in this brief. You can look at it if you'd like to, just as with the minutes, by going down in the description below, clicking on the link, downloading it for yourself, taking a look. But yeah, there's nothing in here that's new in any way, shape, or form. A couple of exhibits that were entered are not even legal exhibits anyway. I'll go ahead and go through these really quickly. The first one is my, looks like a portion of a transcript or maybe my grades or the classes that I enrolled in, something like that to support the fact that I'm in class. And then the second one is the professor's, I guess, his profile. And this is the professor that actually signs the declaration / affidavit for me. This is going to pop up, I think, next video. You guys can take a closer look at it. But yeah. By the way, I'm not sure that there was any point of filing the supplemental brief because the court didn't order it, the court didn't ask for it, and it's just one of those extra documents that some attorneys can get really irritated at. They might file a motion to strike it to get rid of it. I just feel like there really was no point to me filing it. In fact, anything in here that was relevant to the case, I should have included in my motion prior to the hearing, or if I had entered an objection at that hearing to the court hearing this at all, then I wouldn't have really, this wouldn't have been considered after the fact or late, I suppose. All of these arguments could have been incorporated into the eventual hearing that would have come up had I objected in court. So yeah, not really the best approach to how I handle this issue, but I just wanted to go ahead and give you guys that little tidbit of information. And then the last document we have is a proof of service. And this proof of service here is over a demand letter and a dentistry for kids receipt. This is probably me trying to get some kind of reimbursement from my ex, probably consistent with the 30/30 provision. But for whatever reason, this letter and receipt is not included here as an exhibit. So I'm kind of curious as to what it is, but I haven't, memorized it. I'm sure it's just something that I paid for that I wanted to get some reimbursement for. And if that's the situation, that's eventually going to come up. And you guys will see that come up in most likely the motion to modify custody that's going to get filed pretty soon in the My Docket series. So going into the aftermath, I filed two documents. They were free filings and I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, I think, would have spent about 3 hours on that hearing. Maybe 4. I'm not sure about that. It seems like there would have been 4 hours actually isn't that unreasonable, because I think if you count waiting around in the waiting room, plus maybe she would have to debrief my ex afterwards, plus she would have to plan some kind of strategy going in prior. I think 4 hours is reasonable, and we can go ahead and just lump in the minutes, the proof of service, and the supplementary document, that, reviewing these documents. The proof of service, I would say 0. Minutes, I would say, 5 minutes of her time to look at, because it's going to come down to what I mentioned is the actual order. That's where most of the time it's going to go. And then the supplementary document, why should she even bother reading that? She doesn't have to do anything about it. Just wait for the court's ruling. So I think 4 hours at the rate of $250 an hour is reasonable for my ex, which is going to take her attorney fees to $1,000. As with my previous videos, if you have any questions, feel free to post those questions down in the comments below, and I will see you guys next time.